Welcome, my little couch potatoes, to the comfiest courtroom on the internet. I'm your host, Llama, and it's time for dramatic testimony, overruled objections, and absolutely unqualified opinions. So grab your snuggiest blanket, some delicious snacks, and get ready to watch court with your internet besties. This is Couch Court with Llama.
Good morning. Happy Tuesday. Look,
It's Tuesday.
we got a new house.
I love it.
We got a new house. We were a little busy this morning and last night. And, apparently we're going to be having some guests here in a month. So we thought, you know what, let's make it pretty.
Spruce up the place.
Spruce up the place so people want to come to our house for the party. Anyway, I hope you had a good Mother's Day. Did you? I didn't even ask.
I forgot it was Mother's Day.
That's okay. So did my kid. And I was like, by the way, it's like 6. Don't know if you want to say something to me or something. No, I'm just kidding. They were very sweet. I didn't hang out with them for most of the day. I was like, just bring me coffee and wine at an appropriate time. And that's all I need. And just quiet time.
I got flowers and dinner and some cards.
Mm-hmm.
I did ask for a hotel room alone with trash TV and internet access, but I didn't get that.
Hi, Lady in Gray. Good morning. Winks and Wilts. Hello to you, babe. Hope you're doing well today. Apparently, we all had a Mondayest of Mondays yesterday. I know I did. And night. I did not get very much sleep. I was up at 6:15, Buffy.
I know.
6:15.
I know. Who are you today?
That's what us Northerners do. It's 12 hours of sleep in the wintertime. Spring and fall, it either goes up and down a few. And then summer, it's like, 6 hours, let's go. I don't know if it's because, my ancestors were like, we got to wake up early. Otherwise, we're going to die.
Were your ancestors bears?
Bears, probably. I mean, maybe. It makes sense. Hello, up north woman in the woods. Speaking of Northerners, hope you're doing well from Ontario, Canada. I love that. We have a few Canadians. We love to have you guys here. Echoes, hey, how you doing? By the way, I sent you an email to your channel email. I don't know if you got it, but I sent you one yesterday or the day before. I think it was yesterday. So you might want to check that and let me know what you think. It's okay. I'm not good at checking them either. So no, not holding it against you. Hi, Phil Marie. Good morning, LMP. Good morning to you. Kelly Lisa checking in from California at 7 in the morning. The dedication. And here I was bragging about 6:15. I'm sorry. To get up at 7 to watch us. That's awesome. Because I wouldn't.
5. I get up at 5 every morning.
Oh my goodness. I know you do. It's crazy. Hello, Dan Montana. Hope you're doing well. Girl.
That's why I was shocked to see your icon come up over. I was like, wait, what? Did I wake up late?
Did I wake up late? Did I sleep till 10? What is happening? Good morning. No thanks. Okay. And Norwood Novelty. Hello. Well, as you see, we're here a little early. So now that it's, again, a time when Llama can wake up early because she's also part bear, we decided that we're going to start doing our shows starting at 10 a.m. Eastern for a while since I'll be up. But there's so much to cover and get in with each episode now that David Gingras has entered the picture. It took us 4 hours to read one thing he wrote that we didn't want to get too far behind in our plans. So we're going to be starting early. Same days, though, Tuesday, Thursday, Friday, 10 a.m. Eastern. Also, don't forget to like the stream. Lets other people know in the algorithm that we're live and that they're going to want to hang out for whatever is going to happen today. I don't know. Friday was a day. I don't have any booze here, so I won't be.
Thank goodness. No, I'm just kidding.
Hi, Text Packet. Hope you're doing well. Lurking is fine. Lurking is fine. You're up around 5 Pacific. Oof. Oof. Yikes. Well, and then you come listen to us. Oh, that's so nice. Thank you, West Coasters. I just thought about that. That's so nice of you guys. Hello, Bruce. Bruce the Moose and Amos is here. The whole gang's here. Love that. All right, you guys. So as I said, like this stream, post it on your social medias. And if you're part of the replay crew, if you can just hype our stream, because apparently it does great things for the channel, puts us into an algorithm, and that would be really great. That would be really great. And it's all free. It's all free. So that's how you can help us out today and every other day. All right. Well, let's get into what we talked about on Friday, if you remember. I remember, but oof, it was a
I
little
just remember being like this the whole time.
happening. Well, you guys, in our last episode, we finally have gotten to the point in the timeline where Laura gets a new lawyer, David Gingras. And as I said, it took us about 4 hours to read his first motion that was just asking for an extension of time because he'd only been on the case for a week, which should have just been simple. No, it was 30 days.
I forgot that was all he was asking for.
All he was asking for was more time. And he's like, let me list all of the reasons. And we're just like, sir, that's really not necessary. It's not necessary. Oh, congratulations. Happy memberversary, Amos. 21 months. That's like 5 babies. So congratulations. Dave, another friendly Canadian. Hello, good sir. Hope you're doing well. Yeah, I feel like it's only on the phone, the hype button. Don't you have to like scroll the things? I don't know. You know, YouTube. They just
Yeah,
make all the things difficult.
it shows up after the video starts after it's processed, and then you go down where it says live chat, and there's like a little scroll feature.
Oh,
Like you'll see the 3 little dots where it says like live chat or comments, like view
mhm.
live chat or comments, and then you keep scrolling through those, and it'll let you hype.
It's there. Oh, there you go.
But it's only on the phone. It's not on the computer.
Which is dumb. Why
I
is
agree.
that, YouTube? Why is
I don't
that?
know.
Should ask them.
Sure, I'll call them right now.
Thank you. We'll
Call
send
them when I
Terry.
get off the phone. Or when I
Terry
get
can
off
send
the
him an
stream.
email. She emails everybody. It's fine. Oh, hello, Wallace Juno. Hope you're doing well. I'm sorry you had an unpleasant meeting. Well, we will be here to cheer you up. Don't worry about that. So, as we were saying, David wrote 39 pages to ask for what would have been probably a very easy time extension. The lovely Amos let us know yesterday that in that last episode, we said David a total of 356 times. So I apologize to everyone named David because we're going to say it a lot. But you're all the good Davids. This one is, he's something. He's something.
She had a counter going?
Oh, she like went through the transcript and
Oh my gosh.
controlled F'd the word David. And it was 356 times. And she was like, I'm pretty sure Llama said it 349 times. Probably. How could you not? How could you not? Well, today we will be covering Clayton's files to withdraw their motion for sanctions to Rule 26. That was something David brought up in his ask for more time for some reason, but he did. So they are withdrawing their motion for that they had requested in January. We're excited to see how and if Woodnick gets spicier now in his court responses to David, because we did read some emails back and forth between the 2 lawyer teams, and they tried to warn David about his client, kind of. But I think it's going to be pretty a heated relationship between them. And then we're going to get into some of the blogs that David Gingras posted during this time. They've been archived, and we're going to read them, which I don't know how he thought that this was ever supposed to be a good idea. Like lawyers, every single lawyer, it doesn't even matter what kind of client you have. They're like, don't post shit on the internet when you're in the middle of a case. And he's just
Unless
like,
you're Alan Jackson.
challenge fucking accepted. And it doesn't
Alan
go
Jackson seems to get away with it, though.
well. I mean, David wishes he had Alan Jackson's Riz. I'm just saying. Okay.
It's true. It's true.
Who doesn't? Call him Gingy. Oh, I love that. Thank you, Callie, for donating to Mike. Yeah, I have a few more things before I get into that. I have some big news today, you guys, and I'm so excited to share it. We had a very busy weekend. I just wanted to remind everyone, if you're not sure what we're even talking about today, maybe you just found us. We have a whole entire Laura Owens playlist. This is like video, I don't know, 35 or something crazy. So if you're new here, go back, watch all that stuff because it's really important and we have a good time. We do everything here in timeline order, which I think is really helpful because sometimes there's a lot going on all at once. So if you want to know what it happens at the beginning, all the way back with Mike Maricini to where we are now with Clayton Echard, go check out that playlist. Now, the big news, which I was going to do later, but let's just do it now because I'm so excited about it. And that's just how I do that. We'll go back to the comments after this. So, big news, you guys. All right. Are you guys ready for this? So, our team has paired up with the lovely Winks. Where you at, Winks? You're in the chat somewhere. I know you were. I saw you. I saw you somewhere. And her lovely team. And this June, we haven't picked a date quite yet because we're seeing who would like to come on and work with their schedule. But we are going to host a mega stream fundraiser for Mike Maricini. Now, I know this community has already done a lot of fundraisers, and you guys have done an amazing, amazing job. But we were talking and we realized that so many other communities will do these huge mega stream fundraisers, 12 hours, 24 hours. We're not getting that kind of crazy. But I've committed to host 12 hours, hopefully, if we have all the people, of full fundraising, a whole day event. I'm going to try to get other creators on here, advocate, whoever wants to come on to help raise money for Mike Maricini. If you don't know, Laura is fighting an appeal as the DVRO she had on him was dropped because she didn't bother showing up. And now she wants to appeal it. And that's a whole different lawyer and it's a whole lot of money. And we know that Laura doesn't make anything simple for anybody. And Mike and his family really need our help. So right now we're putting out to everyone that's creators who want to help in some way. You can either email myself, Llama, at Tara, Tara, at tcwtmedia.com, or Winks at, hold on, she has numbers in hers that I forget. Where are we at here? Oh, there we are. Winks, WINKS 5813 at gmail.com. We got it scrolling along the bar. We do have a list of people, but we don't want to forget anybody. So go ahead and reach out to us first if you're able to help us out. If you're a creator, we're just asking like 10 to 30 minutes minimum of your time. You don't have to sit here with me all 12 hours. But we would love to have you on, whether you've covered Laura Owens or not. Maybe you just heard about it from Love Trapped and you want to get in on this and help some victims out. We would absolutely love to have you. We're going to do panels, have activities. We had a huge brainstorming session this weekend. So you're going to hear me talk about this a lot because I'm very persuasive. And this is peer pressure. Lots and lots of peer pressure. I'm just kidding. But we are very excited about that. Every stream we are going to have Mike's fundraiser pinned to our chat in our description. And as you can see, I forget how the pointing works. By my face is a QR code that'll take you right to his GoFundMe. All donations, nothing is collected by us, including the Mega Stream fundraiser. You're muted, by the way, babe. So we want everything to go directly to him because YouTube also likes to take money. And this way, he gets all of the things. That way? Okay. So that's our big announcement. We'll be talking about it ad nauseum every single day. Like I said, if you can help in any way, maybe you want to donate an item to an auction because we're going to try that out. There she is. There she is. Sorry, there's a lot of messages. Please email me or Winks and we will get the details and set something up with you guys. So we're so excited about it. Generally, I stream trials so I can sit here for hours. I've done 8 to 11 at night before, so I can do it. And plus, this is going to be way funner than court. So I'm very excited about it. Now, yes, Echoes, I yelled at him already. Winks. I said, is your email? No, I'm just kidding. I even cleared out my, you know what I did, Buffy? Because everybody that knows me knows that my emails, it's a graveyard. Has been for years. I don't check them. I don't delete them. It's not a good time, right? Our digital clutter. Well, guess what I did? I cleared it all out. My work email, my personal email. Just boom.
I'm so proud.
Yeah. 13 years of shit. You know how many messages
I don't
there
even
were?
do that.
87,000. Google keeps hounding me, being like, girl, you are out of space and you're going to owe us money. And I'm like, not though. That's probably why everybody has to pay money now for extra storage. It's my fault. It's fine. But my inbox is now clear. So you all come fill it up with awesomeness. Okay. Hi, Allie Firecat. Sorry if I missed anybody. I was too excited. But hello to anyone that I did miss. I apologize. Again, I've been up since 6:15. I've had a lot of coffee.
I love
A
it.
lot of coffee. So before we go getting in, I promise you all Friday, because we didn't get to showcasing any of our comments from our lovely replay crew, because I may have gotten a little, behind and tipsy the night before or whatever. Oh, wait, no. It's because the bus didn't pick up my kid. That's right. Don't blame it on the wine, Llama. Jeez. So I went back to our Thursday and Friday shows and took some of the comments out. I want to say special thank you to the replay crew who can't be here while we're live. You still matter to us, though, and we love reading all of your comments as you discover things in real time with us. It's the best. So thank you. No thanks, okay. LSB, Angie RN, Wallace Juno, and Minnie T. And Minnie T, who also gave us some hype points. So thank you for that, babe. Everybody be like Minnie T if you're on the replay crew. Then we have some comments I thought were really good. We have Mom's Biscotti, which I love. I love people's names so much.
And every time I
pleased.
read that name, I start like rapping.
Like
Eminem.
Eminem. Me too. Me
Not
too.
good. Not rapping well, but it's what it makes me think of.
Amos, Google's sending a welfare check now because the activity in your email is very, very strange. They're probably like, you got hacked. Well, if I did, at least they cleaned the place up. You never get love notes from Laura or David? Oh, I'm waiting for mine too. Don't worry. Hello, Toda. Just Jen. Good morning, friends. Everybody make room in the couch for everybody. All right. And then also thank you to Echoes who wrote, it's so much fun hearing you two discover the unfolding insanity. And yes, that is exactly what's happening, and possibly killing some brain cells at the same time. Because, whoa, David.
Yeah.
Now, also, Laura Crabb wrote, this woman is awful. Agreed, Laura. Good Laura. We're going to call you good Laura Crabb, okay? This woman is awful. She flat out refuses to let anyone out of her control, to the point where she will destroy her own life just to cause these men a tiny amount of pain. Exactly. Couldn't agree more with you, Laura Crabb. Good Laura. We're going to maybe change your name to Good Laura. What do you think about that? And then we have Kelly R. Cross, who wrote, "You have to read the llama calls me a bitch in the same voice as Steve called me a dumbass." Oh, I will. Okay. Llama called me a dumb bitch. We'll get a clip of that, I'm sure, at some point. Oh, the gift that keeps on giving. And I'm some lady also wrote us and said, "I went to my local Planned Parenthood about 20 years ago." Oh, that's right, because Laura has claimed now that she went to a Planned Parenthood under a different name and she doesn't remember when it was, and it was in this place because, of course. So and I'm some lady went on to say, "I had to be buzzed into a vestibule. Thank you. And show ID. I had to show it again to the receptionist behind bulletproof glass. And that was 20 plus years ago. And I'm sure they are even more careful now. I'm sure too. And thank you for sharing that. And I'm some lady. It's always best when people share their experiences and be like, "You lie, Laura." She lied. Ed Nord with Novelty wrote, "The fact that she straight up said, regardless of how they rule in the appeal, she's going to submit another DVRO for Mike. She's incapable of letting him go." And I agree with you, Nord. And that's why I think we need to try to raise as much money as possible for him right now, because I have a feeling, because the other two are currently victims in her criminal case, it would be real stupid, for her to, do anything with any witnesses. And Mike may be on the witness list, but I don't think he's, listed as a victim on that because that's in San Francisco. But she might take out everything on him. And, he's the only one that stayed in a relationship with Laura. And in my honest opinion, an abusive relationship. She was very emotionally abusive to him. So that's another reason we just want to do a really big, giant fundraiser. Sorry, the sun is attacking me through the window. Hold on, I will be back in just a second. Oh my God. I need sunglasses. Okay. Riveting stuff, Buffy. Oh, no, it's still doing it. Okay, hold on.
Oh, did you want me to say something?
No, it's fine. I will narrate my troubles because I'm fighting the sun today. Oh, what is this? Okay, I'm just gonna have to put
I'm
something.
having fun listening to you yell at the sun.
The sun? Damn you, sun. Stupid sun. That's important, apparently. Okay, I think that worked.
It's the Mondayest of Tuesdays. It's always the Mondayest of Tuesdays.
Ugh, every day's the
Everything.
Everything. Anyway, so thank you all for leaving comments. We love you, replay crew. Even if you watch this live and you want to leave comments later because you thought of something, please feel free to do that. And we would love to see them. So with that, let's start getting into things. All right. I don't need my sunglasses. Okay, I think. Probably
But
for
it
like
would be
10
really
minutes.
fun.
Probably for like 10 minutes, and then it's going to shift over and I'll be like, ah. All right. So let's get into where we left off on Clayton's costs because, we already did that. Because we are keeping track of Clayton's legal fees as we go along, which is an even better reason to donate to Mike Maricini's GoFundMe, QR code, description, chat, because as you can see, bills pile up real quick. Legal fees pile up real quick. And we'll do other fundraisers for, of course, the other victims in the future and whoever else. But this is the active one going on here. So, but anyway, we've been tracking this. Clayton is currently sitting on $58,000 in legal bill from December to what month are we in? Oh, the beginning of April 2024. That's crazy.
Crazy. That's crazy.
Yeah.
Doesn't it make you sick though?
It does. It does. Hi, Cracked Pepper. You ladies make my workday so much better. Please never stop. Oh, thank you. You're so sweet.
Aw.
Thank you. Hi, Kelly Cross. How you doing, babe? That's right. Every dollar helps. And listen, if you can't donate, one, don't trouble yourself if you don't have the money. Okay, that's okay. You can always share it on social media, put it out on your private, you know, Twitter or whatever it's called, X. I don't know social media, Insta, Facebook, whatever. Sharing it is just, if not more important to raise money for him. I think the community's already raised $20,000 ish in the last week or two, which is amazing. So I'm really excited about doing this for him because he seems like the nicest guy. Viking J Max says she acts like she owns Mike and just can't comprehend him living his own life. Agreed.
It's true.
Agreed. It's very true and fucking weird, Laura. Leave him alone. The effing son. Hi, Miss Holly. Hope you're doing well. Thanks for joining us. I know, Ajad. The legal system is broken like a lot of things in this country. It is, but that's why we need transparency. We, the public, need to keep an eye on it and try to do something about it the best we can. Sometimes we can, sometimes we can't. That's kind of like a lot of things, but I agree with you. Well, it says, love that you're tracking this, Llama. It's very illuminating. And you know, this community loves our facts-based commentary. Yes, you guys do. Honestly, the best community on the internet, if you ask me. But 20K in a few days. Freaking amazing. Amazing. I'll tell you
It
what,
is.
everybody is just so inspiring and motivating to see people like working together for the bigger picture, especially, as Agent pointed out, things aren't going the greatest in a lot of areas. So when you do see something as beautiful as that, it's just really inspiring. You're like, oh yeah, humanity is something wonderful. So, and we're so happy and blessed to be a part of it. All right. So that is our starting total for today. First thing we're going to read. Let's get into it. This
Oh my
is
goodness.
Clayton. Don't worry. This is Woodnick. We're not starting off that strong this morning.
I was like, oh God, I was not prepared.
No, don't worry. We're going to start off with probably a little, a little not so.
You're going to ease me into it.
Well, some foreplay, I guess. All right. So this is their motion to withdraw, motion for sanctions pursuant to Rule 26. This is filed today. We are covering, I think we're just covering April 3rd. Everything we cover today happened on one day, April 3rd, 2024.
Really?
Yeah. Yeah. That's why we're like, oh, we're going to have to start early because we were covering, like numerous days. And now it goes to a lot of shit going down like every single day.
Oh my gosh. Okay. All right.
So just keep that in mind as we sit here today.
This is all one day.
One day. Yeah. All right. So respondent Clayton Echard moves to withdraw only his motion for sanctions pursuant to Rule 26 dated January 3rd, 2024, based on the following. Although Clayton believes he more than complied with Rule 26. Oh, that's right. Because Gingras was like, you didn't put the good faith certificate. And it was just went on and on and on about it. But okay. So they're like, all right. He more than complied with Rule 26 and that the court already overruled Laura's objection. It is clear she intends to pursue more toxic litigation predicated on threats as a ruse to avoid this court reaching the heart of the matter. The overwhelming fraud. Well, okay. Woodnick starting off with shots fired.
Right?
First one. Okay.
He's just putting it out there. I mean, I think you kind of have to with this guy.
Right? Okay. Clayton's claim for fees and sanctions exist independently of the Rule 26 motion and have already been set for trial. Clayton would rather avoid the $35,000 sideshow repeatedly threatened by Laura's new counsel and overt
Sideshow.
efforts to delay adjudication on the facts. Oh, so let the fighting begin. We should have had some wrestling bells. Ding, ding, ding. Wow.
Let's get
Okay.
ready to rumble.
Dun, dun, dun. Some jock jams. I love jock jams. That was like the CD in my car for a very long time, like as an adult for like 6 years. Love jock
Very
jams.
telling.
Anyway. Oh, hi, Terry. Hi. Yes.
Morning, boss.
Pink today. Your pink girlies are here. Hello, barbecue queen. Hope you're doing well, babe. Say cheese. Good morning. Good morning to you. Hope you're doing well. All right. Because the Rule 26 motion is not the substantiative pleading basis for his claims against Laura, there is no reason to participate in the pointless litigation over this issue and threats to appeal to further delay justice. Sound familiar? Donate to Mike Maricini. Notwithstanding Clayton's disagreement with Laura's legal positions on Rule 26. Moreover, Laura's threat to seek personal sanctions against Clayton's counsel based on her proffered Rule 26 violation, while frivolous, will only draw more attention and animus to this case, subjecting the court to this collateral circus, which is intended only to increase legal fees and prevent resolution on the merits, would be a waste of judicial and other resources. Oh, shit. Well, okay. Tell us how you really feel, Woodnick. Okay.
I believe he's going to.
Mm-hmm.
It sounds like he's gonna.
Wow. Spicy.
I mean, he tried to warn him.
He did. He did he was trying to be nice about it. Now he's
Well,
like,
for a
listen
little
here,
bit.
motherfucker.
And then
Boom.
he like laid it all out there. Yeah.
Right? Now, accordingly, Clayton hereby moves to withdraw the Rule 26 motion for sanctions filed January 3rd, 2024. He does not withdraw his counterclaims and other relief afforded and any other relief appropriate and available to him. He also, for completeness of record, provides the following background and procedural history. This matter is before the court on petitioner Laura Owens' petition to establish filed August 1st, 2023. Excuse me, the burps are already here, guys. Sorry about that. And Clayton's amended response to petition to establish paternity filed December 12th, 2023. On December 12th, 2023, Clayton moved for leave to amend his response. In the amended response, Clayton cited Rule 26 and provided notice of intent to seek sanctions for statements made in Laura's petition. The court granted leave to amend and accepted the amended response on January 25th, 2024. On December 28th, more than 10 days after notice of Clayton's intent to seek Rule 26 sanctions via the motion for leave to amend, Laura moved to dismiss her petition based on her assertion that she was no longer pregnant. How convenient. Convenient. Her motion to dismiss sought to dismiss the entire action with prejudice, meaning they can't bring it back up again. And Clayton said no. Clayton objected because he had alleged counterclaims seeking an affirmative finding of non-paternity, attorney fees, and sanctions for Laura, bringing the action in bad faith for improper purpose. Oh, you know what, Laura Crab? You should be Laura Good Faith Crab. There you go. That'll separate you from the other Laura. On January 25th, the court granted Laura's motion in part by dismissing her petition, but the court did not dismiss the action because Clayton is entitled to resolution of his claims for a finding of non-paternity, attorney fees, and sanctions, right? So the whole parenting plan is out the window. That's fine because she's not pregnant anyway. But the judge is like, we're going to keep this open though, because there's some other stuff we need to talk about here. Let's see. On January 3rd, 2024, Clayton filed a motions for sanctions pursuant to Rule 26. The motion for sanctions came more than 10 days after the motion for leave to amend, in which Clayton gave written notice of intent to seek Rule 26 sanctions from Laura's complaint, and after Laura moved to dismiss her petition. Okay, so that's the, what did David call it? Safe harbor that David was complaining about, right?
I was about this safe harbor. Yeah.
Yeah. Or you have to give them 10 days notice. You guys didn't give Laura a 10-day notice. And judge, I need more time. That's why I wrote all of this. But I'm going to bitch about everything else at the same time.
He's going to spend 10 days writing a motion about it.
Laura responded to the motion for sanctions on January 23rd, 2024. In her response, she argued that the motion was deficient because of lack of notice required by Rule 26. She also was in between lawyers, but what? Even when Alexis withdrew as her lawyer, she still represented her up until the day Corey came on. So it's not like Laura was really without counsel. At the time she filed her motion to dismiss, Laura was, I got ahead of ourselves here. Laura was represented by Alexis Linville. At the time she responded to the motion for sanctions, she was represented by Corey Keith. Again, Laura brought the same argument relating to Rule 26's 10-day notice requirement in her response to the motion for sanctions, albeit with less force, and the court still set the case for trial. Ostensibly, because even if she is correct and Clayton's 26 motion is denied, there remain other claims that must be resolved before the case concludes. Her current attorney, as of the time of this filing, which I feel is some shade, feeling like, maybe 6 around.
Oh, well, 100%, it's 1,000,000,000% shade because, like, he even told what Gingras during that email is like, well, we won't even know how long you're going to be around. Like, he's made it quite clear that he's throwing shade at the carousel of lawyers.
Thank you, Minnie, for donating to Mike's GoFundMe. I'll thank you on his behalf. Thank you guys who are doing that. If you just got here, this QR code is to donate to Mike Maricini's fundraiser for legal bills. It's pinned in the chat and in the description. Please go help him out. If you're not sure who that is, go check out our Laura Owens playlist where we tell you exactly who that is and what Laura did to him. I think it's like 4 episodes.
Yeah, it's definitely like not 4 hours.
No, that's just like what? It's like 20 hours of her just being a fucking dick to this really nice guy. So if you can, awesome. If you can't donate, that's fine. Share it on social media. That's free and is just as important and helpful. And hit like on this stream so that it lets everybody know where the party's at today. Now, where was I? Where was the shade? Oh, yes. Her current attorney, as of the time of this filing, David S. Gingras, began aggressively asserting various claims, positions, and legal threats in emails to Clayton's counsel after entering appearance on or about March 25th. Several of these unpleasant emails pertain to the motions for sanction under Rule 26. Ooh. By the way, I think we get to read a lot more emails too, which I love. I don't know if with this
I
one,
do.
but I
do love a lawyer email.
I know, right? Laura asserts that the motion was improperly brought because of a lack of written notice required by Rule 26, hereafter referenced as the safe harbor notice. This argument is particularly articulated beginning on page 14 of her motion for extension of time. Wait, I saw somebody say that Bruce did some math, but I forgot to click on it. Oh, Echo said Bruce did the math. It was more than 10 days, if I remember correctly. I'm gonna go with if Bruce did the math, and yeah, then he probably got it right. So he seems like a very knowledgeable moose. So yeah, we're gonna try to get everyone that can be available to be on. So a star-studded event, I hope. If not, that's fine. I'll just sit here for 12 hours and do something. No, I'm just kidding. I know people are already interested in it, so it's going to be very, very exciting, and for such a good cause.
Your microphone's cutting out.
Oh no!
You sound a little robotic.
Hold on. Maybe. Is that better?
Yes.
Okay. I did nothing but mute and unmute. So
hopefully it'll last.
Oh, class, we're going to Aldi's. No thanks, okay, if you need anything from there. Ms. Wings, hello, good morning. Everybody be like her and hit the like. Lord does.
The clown car.
Oh my goodness. All right. So according to her argument, Clayton did not provide sufficient. Oh, wait, didn't I already read this? Yes, I did. I'm sorry. She interprets withdrawal, or appropriately correct, as giving her an absolute right to withdraw her pleading without consequence or further proceedings. Well, yeah, Woodnick, it's Laura. She shouldn't face any consequences. What is it, your first day, Woodnick? Jeez. She's a horse princess. Now, further, Laura appears to believe she should have had the right to withdraw her entire petition by virtue of Clayton moving for Rule 26 sanctions without the safe harbor notice, notwithstanding Rule 46. She bases her renewed objection to complying with discovery orders and disclosure obligations on this notion. Quote, the only current remaining issue in this case is Mr. Echard's motion for Rule 26 sanctions. Oh, I forgot. This must be what it's like to have ADHD. I'm just all over the place today. Now I know how elbow feet feels. I'm like, oh, something shiny. I forgot. I got these dinosaurs. Elbow feet got them for me because I was very sad on Friday. So this one is David Gingras with the anytime he says something, that's what I'm going to do. So he says, the only current remaining issue is the case in Mr. Echard's motion for Rule 26 sanctions, which is presently set for evidentiary hearing on June 10, 2020. The pending motion to compel seeks evidence which is only and could only be relevant to the issues of sanctions, because there are no other pending issues for this court to address. Thus, the only fact of consequence necessary to determine this matter is the question of whether Miss Owens lied about ever being pregnant in the first place. Mr. Echard has no right to this discovery, or indeed to any discovery, because none of the discovery is relevant to any of the remaining issues of consequence in this case. All right, sorry. I'm only going to do that one time. Put the dino down, Llama. Why do you hate dinosaurs? Llama hates dinosaurs, everybody. I'm just kidding. I'm only going to do that one time. But he did. He got me 3 of them. I don't know where the other one is. I got a raptor, I got a T-Rex, and I got that one, which I don't know the name of. B always tells me, and I always forget. And I'm like, I don't care. I already gave it a name. This is how Laura needs to be talked to. I'm going to get puppets, Barbecue Queen. I'm going to get puppets. All right. So this untenable position completely ignores the court's trial setting order and Clayton's amended response. Clayton has requested relief to which he is entitled under Title 25, including a finding of non-paternity and attorney fees and costs that are entirely independent from the Rule 26 motion. The applicable statutes attorney fees and costs for filing in bad faith, filing without grounding in fact or law, filing for improper purpose in legal decision making and parenting time proceedings, and all this other stuff, provide independent remedies that have no grounding in Rule 26. Based on the court's comments on the record at the most recent status conference that I know you weren't at, David, but you could totally have watched it, probably should have, and the order setting trial, the court intends to hear those claims for attorney fees and sanctions, notwithstanding the Rule 26 motion. That is why the court did not dismiss the action in its entirety. The court must first resolve Clayton's claims for relief. Very serious about that. Laura's current counsel's communications on this topic are tremendously aggressive, and counsel has taken to Twitter. Because of course he did. That's always a good idea. Posting pleadings and medical documents contrary to the court order. All of which the court will have to determine the propriety of reasonableness under the special code come a trial. Oh, David.
That's right, because they were ordered not to share medical records, both sides.
That's right. Both sides. Do we have we have no sounds. Should we play one? What's a good one for David?
A dick, David.
Dick, David. We, Buffy May, have put together a lot of David quotes from Schitt's Creek, so prepare yourselves.
Well, I'll take a little bit of the 390 something Davids. Oh.
Llama, can't say them all.
Well, I mean, you can. We proved that.
Let's see, where were we? Okay. These communications include declaring that Clayton refusing to withdraw the motion would itself be sanctionable under Rule 26, promising to litigate the issue to higher courts at great expense to both parties, threatening to seek personal sanctions against Clayton's attorneys, threatening new bar complaints because, of course, Laura, having already filed 2 against undersigned counsel and at least 2 prior attorneys and so on. So 4 bar complaints she's filed already. So, okay. He just needs to fold in the cheese. Just fold it in, David.
I don't think he'll. Yeah, it's going to be a 38-page blog on how he folded in the cheese.
Probably. These mean women on the YouTubes. Yeah, I know how to fold in cheese.
Oh my gosh, can you imagine?
Just fold it in, David. All right. In one example, counsel estimates $35,000 in risk if Clayton does not withdraw his motion for sanctions. Do we want the dinosaur back? No, I'm just kidding. If I was in your position, I would seriously stop and think about that before telling me to go fuck myself. You can literally avoid about $35,000 in risk simply by admitting you made a mistake, then doing the right thing. If you decide not to take that safe harbor, it's your decision, but a pretty freaking bad one.
He does that a lot, seemingly. It's just tell people how wrong they are.
You wrote that in an email to another lawyer?
Yeah, we read that last week, or
did we? That
Friday.
One? No,
yeah,
not the risk one, the 35,000. Oh,
well, I thought that part. I believe we did because I remember the "go fuck myself" part.
Oh, maybe, I don't know. I started drinking at like noon 30 on Friday, so I don't know. All because of David. Now, it is not clear.
Up in my head.
It could be. It is not clear whether the $35,000 is a prediction of legal fees for both parties, a possible attorney fees awarded to Laura for acts not yet taken, an amount expected as a sanction, But what is clear is that Laura's scorched earth approach to this litigation remains the same as always, to threaten and drive up costs in an attempt to exhaust Clayton's remedies and willingness to defend himself and seek affirmative relief to which he is entitled under Title 25. And if you're like agreeing with me, like, yeah, Llama sure does. That's exactly what she does. And please go donate to Mike Marashini's GoFundMe, because that's exactly what she's doing with
That's
him.
exactly what that's what I was just thinking. I was like, oh, yeah, the pattern.
She may be batshit crazy, and we're always like, I can't believe she did it, but she does have patterns, batshit crazy patterns, but patterns nonetheless. The emails also concede, however, that, quote, there are other options available to you if you want to seek fees, like date me for a week. You have not made any other motion seeking fees under those other authorities. If you think you have a factual legal basis to do so, go for it. Winnick, if you date me for a week, if you go out to lunch with me for a week, then I won't file $35,000 against you. Okay, great. This is like a match made in heaven. Well, hell,
Yeah.
really. It's hell. It's definitely hell. But who knew those two would find each other? It's
That's kind of
crazy.
scary.
That is
That's
scary.
like when gasoline meets fire. You know, like some people are just this way by themselves, but like when you put them with somebody who constantly feeds it, it amplifies and makes it so much worse. And I really feel like,
Oh boy. Right? Oh man. Yikes. No, she's not. Nord says she's so self-aware, but also basically said she's not going to lift a finger to do any kind of treatment. Of course she's not. Of course she's not going to do anything to help herself or the world or anything like that.
I
Now,
mean, you
Clayton
can be
is
self-aware, but still not want to go get like do anything about it.
right.
There's a
Which is
lot of
even
people who
worse.
know.
That's
There's a lot of
true.
people who know how crappy they are, but don't really want to fix it.
That is very true. Very true. Now, Clayton has already invoked these claims in his response, amended response, and various other filings and positions in open court. Laura's position self-contradicts in that it simultaneously declares Clayton has no avenue for relief other than Rule 26 and therefore should have no discovery, but also that he can bring claims for relief under other authorities. Which one is it? As a threshold matter, the policy implications of Laura's position that Rule 26's 10-day notice and safe harbor language grant an absolute right to withdraw a petition and defeat the responding party's entire case are both severe and obvious. A party who has already filed a response and brought counterclaims for relief would never invoke Rule 26 if doing so would give the petitioner carte blanche to withdraw their pleading with no limitations. Rule 46 expressly prohibits voluntary dismissal of a petition after a responsive pleading is filed or evidence is taken, particularly when the responding party alleges affirmative claims for relief, as Clayton did here. So basically, what? Like you already filed something, so missed that window. Too bad. The suggestion that Rule 26 10-day notice supersedes Rule 46 is illogical and would deter parties from seeking Rule 26 relief at all, especially in cases of the most egregious conduct. Rule 26 is meant to prevent. I think we have a sound for that. Where's
what
a Leslie?
Could be more egregious? What could be more misleading?
Exactly. Exactly.
I love him.
I do too. Rule 46 locks in the party's petition once a response is filed and guarantees the respondents the opportunity to present their claims for relief, even if the petitioner changes their mind and wants to opt out of the litigation. Because why wouldn't there be that option to do it when people can bring really frivolous stuff. I mean, otherwise,
I know that
even
I
more.
need a cheat sheet for all these rules. I need like a Post-it note in the corner of my desk that's like I can just glance up and go, "What's rule 26? What's rule 46? What's rule
I know.
49?"
They don't matter. Just kidding. I don't know. We're gonna learn a lot about Rule 26, I feel. Yikes.
I think I
Now,
just want a shirt that's like black with white writing that says rule
just Rule
26.
26.
If you know, you know.
Laura is correct that failure to comply with Rule 26 results in relief for that motion being denied. But to suggest that failure to comply with Rule 26 results in effective waiver of all claims in the litigation would interpret a procedural provision of one rule in a way that swallows the entirety of another. A harmonious reading of Rule 26 and 46 is simple. Failure to comply with Rule 26 results in not receiving Rule 26 sanctions for that motion. It does not
You know,
prohibit.
the irony is not lost on me that he used the word swallows.
Oh,
And I really wish that would have been highlighted a little better.
I didn't even pick up on that.
I know. I was waiting and I was like, okay, I'm going to have to interrupt her here. I was like, a missed opportunity, would Nick?
I forgot BJ's is what got us here. It does not prohibit oh wait, no, I already read that part. Laura's interpretation would, nope, back up, Llama. There we go. It does not prohibit a subsequent Rule 26 filing with a new 10-day notice, nor does it afford a party who violated Rule 26 an opportunity to dismiss the entire litigation during the 10-day notice period. Laura's interpretation would render Rule 26 practically useless because no party with valid claims for relief would risk waiving their right to resolution of those claims, a right guaranteed by Rule 46. Okay. Yeah, don't forget, that's why we're here, friends.
Sorry.
The BJs. Oh, right. Definitely need a Samuel L. Jackson soundbite for sure. Would love that. Where were we? Okay, Rule 26 procedural requirements do not supersede independent claims for relief given by law, including claims under this code and 809. Nothing in Rule 26 indicates, nor could it give the supremacy of statutes over procedural rules, that a party waives their right to bring their statutory claims by invoking Rule 26. This would create an absurd result and exalt form over function in a most problematic way. So again, they're just saying like it would only be for this specific motion we filed, not for the whole fucking thing. All right. You should know better. Doesn't even make any sense, is what they're trying to say. Oh, now we're going to learn the differences between 26 and Rule 11. Okay. Take notes. There's going to be a quiz. Just kidding. There's not going to be a quiz. I'll fail it for sure, even if I put it all.
I just said I needed a cheat sheet for these rules. Because I don't even know.
Hi, Berkeley. Berkeley Farms says, going over this again, I know why Megan Fox says that Rule 26 sound clap, they say it so much. Maybe we can file a what are the group lawsuits called? Civil action
Yeah.
for PTSD from the number 26.
I don't know. We can just emotional distress, I feel like, at this point.
This is why you do criminal law. I mean, we don't do law, but like I much prefer following the criminal court system than the civil stuff. This is crazy bananas over here. What is happening? It's like the wild west over in the civil court area where things just don't make sense. At least in the criminal world, for the most part.
I was about to say, I feel like the criminal side just kind of follows like a straight line. Sometimes there's like what, but like for the most part, but I feel like civil is just there's so much minutia. There's so much hair splitting.
Yeah, no, thank you. No, thank you. Though this is fascinating, but I will not be all in to civil court stuff because it's so confusing. No wonder they charge so much money.
Or maybe I think maybe he's just making it confusing.
Oh, for
more
sure.
confusing than it needs to be.
Yes. What looks like, what the fuck are we doing here? Are you serious right now? Do I have to teach you how to be a lawyer? Jeez. Class action rule 26. Have you heard real too many? Oh, I'm sorry. I didn't read that right. Have you heard real too many too many times? I'll fill out this paperwork and return it. I think that's a great idea. Let's do it. Said cheers, said civil attorneys are ironically less civil than criminal attorneys for the most part. Yeah, that's the vibe we're getting too. Like, geez, at least there's not been very many trials we watched where the state and defense were so like combative the whole time. I mean, we've seen a few. It does happen for sure, but
I don't think we see their emails.
Right? Like this, wow, could never, unless, you're in Massachusetts. Now, where were we? Okay, Laura herself believes correctly that attorney fees and sanctions are available under Arizona Code independent of Rule 26. Clayton has already identified this statute and at least two others in Title 25 that similarly require the court to consider reasonableness of positions, bad faith, improper purpose, etc. as part of this action. None of these statutes apply to general civil matters in the state or federal courts. Put another way, Rule 11 precedent exists in a completely different legal context where awards of attorney fees are more limited, such as fees provisions in contracts under Arizona Code, damages not to exceed $5,000 for frivolous claims, delay, or discovery abuses, liability for excessive costs. Okay. Clayton denies that these cases, or indeed any Rule 11 case at the state or federal level, categorically disposes of analogous issues under Rule 26. They're making me say all the words today, Buff.
26, 11, 49. It's like a football play.
It's our new lost numbers. We're just going to be like repeating.
I'm going to go play the lottery with those numbers just to see what happens. Someone can get me like a lotto ticket.
Right? Yeah, the Karen Reed trial was unusual. Fascinating to watch. Oh, that's true. That one was pretty highly contested. I have to ask, did y'all take an Advil or Tylenol before you read these? Because I know I would need one.
No.
No, not yet.
No.
We're just raw dogging this sober.
I was about to say, nah, we're raw dogging it.
Yeah. Now, accordingly, the movement's alternative claim for sanctions under the court's statutory authority was unavailing, and they brought no substantive legal basis to request those sanctions except under their flawed Rule 11 motion. I'm sure that David responds very well and maturely to this filing. I'm just saying, I bet he handles it.
He sounds like a very rational, calm person.
Totally. I bet he does. It should also be noted that Holgate decision expressly declines to award sanctions for a Rule 11 notice error or for opposing a plaintiff's motion for voluntary dismissal, stating the appropriate remedy is to deny the request for Rule 11 sanctions, not award counter sanctions, as Laura threatens to request. Holgate at 680. Okay. Clayton denies his Rule 26 motion for sanctions lacked proper notice, but even if it did, Laura's threats are contrary to the very precedent on which she relies to make them. Okay. Do we need to say to the court, well, this is just a withdrawal, a sanction, a motion at this point. Is this really necessary? Do you have to do
Well,
this? Can you just
he's
be like,
very
never mind?
wordy because Gingras is wordy. This judge hasn't gone like, you know what? Burn it all. Like, I am done with you guys.
Right? Use Rule 26. Use 26 as the Powerball. That's what we're going to do.
I would give them all a word limit, a character limit. Like, if I was the judge.
Don says, pretty sure Rule 26 has hurt me more than any asbestos claims. I go to sleep with it ringing in my ears. And Sean says, Civil always just ends up feeling like I'm reading people arguing on Facebook. Yes, that is the perfect way of saying that. That's exactly what it feels like.
Let's say you paused for a
Exactly.
second.
What?
You glitched out for a second.
Oh, did I? Oh,
Yeah, you stopped and everything. I was like, oh no.
even the StreamYard is just like, we need a second. Say Cheese says Arizona needs a Rule 26 LO. I see what you did there. In order to file a claim of paternity, you must establish actual proof of pregnancy.
Has anybody made a like movement to like get a law written or a
Maybe.
rise statute and just call it that? The LO.
Hello.
That would be so funny. I would die.
She wanted to be famous so bad, but not like this. Well, monkey paw, Laura. All right. Where were we? Okay. So similarly, Laura relies on Gallagher versus Serrano Law Office, a trial court decision summarizing applicable Rule 11 precedent. Okay. Although Gallagher is not presidential, that's not right. Precedential. Sure, why not? Clayton finds the same problem with the analysis in that case. The party seeking sanctions cited this thing as an alternative basis, but did not prove the required factors, including bad faith, subjective intent, financial positions of the parties, etc., like we do. Critically, the court considered awarding fees and sanctions under authority unrelated to Rule 11, notwithstanding the movement's failure to comply with Rule 11's 10-day notice requirement. Ugh, okay. Mark a calendar or something. It's crazy. This case does not stand for the proposition that Rule 11 is the exclusive mechanism for seeking fines and sanctions. The court declined to award the statutory remedies, but the fact it considered them belies Laura's position that the 10-day notice in Rule 26 gives her an absolute right to withdraw her petition and thereby dismiss all Clayton's claims. Title 25 is far more remedial and contains numerous mechanisms for fees and sanctions that do not exist in the Rule 11 context, warranting a much broader interpretation of Rule 26 and the availability of other remedies. You know, I don't understand a lot of this, but one thing that does make sense is when I put together the cost for the slideshow for today, that bill makes a whole lot of sense now.
Well, yeah.
Wow, like this is very legal war happening here.
Oh yeah, there's a
and
lot of case law and stuff being
yeah,
cited.
this motion to withdraw a motion costs a very pretty penny. Yikes.
A lot of research.
Mm-hmm. Absolutely. Now, this is usually what, court documents read like, but not.
Well,
in this
yeah,
case.
but I
Yes,
feel
which is
like
less.
this just seems like intentional to bleed him dry.
Oh, yeah, absolutely it is. Absolutely. So Laura also cites Barber versus Miller, another Ninth Circuit case involving an appeal from FRCP sanctions without the 10-day notice. The primary issue in Barber is whether a party receives sufficient notice, an opportunity to withdraw, or correct their offending filing when the movement moved for sanctions after the complaint had already been dismissed. The movement also failed to serve a copy of the motion before filing under a prior version of Rule 11 that required service of a motion for sanctions and a 21-day waiting period before filing. This is why everything costs so much fucking money in civil court. It's like we can respond once every 2 months, and it takes 3 months to get a judge to fucking rule on anything, it seems like in this case. Oh my gosh, it goes on forever. Sorry, guys. The Barber Court reversed the sanctions because a party cannot wait until after summary judgment to move for sanctions under Rule 11. I think I read that already. No. In Barber, the court also devoted significant attention to the difference between Rule 11 sanctions imposed by motion of a party and imposed sua sponte by the court. Is that how you say that, sua sponte? Why not? We're just making stuff up anyway, so it's fine. Barber states that sanctions imposed upon motion of a party and those imposed by show cause order on the court's initiative are substantively and procedurally different. Critically, the version of Rule 11 the Barber Court interpreted only allowed an order for payment of attorney fees directly to the movement if imposed on motion, not on the court's own initiative. Okay. She is the same level of evil from The Handmaid's Tale. Ugh, that show, man, full of a lot of evilness in that show. She'd be like the cult leader's wife. Oh, it's the new one? I haven't watched any of the new one. Okay. Where was I? The Barber Court could not interpret the sanctions award as the equivalent of an election by the court to impose sanctions on its own motion because the rule did not substantively allow that form of award except by motion of a party under the version of Rule 11 then existing. Okay. Contrast with Rule 26 allows the court on motion or on its own to oppose an appropriate sanction, which may include an order to pay the other party or parties the amount of the reasonable expenses incurred because of filing of the document, including a reasonable attorney fee. We get it. Okay. Rule 26 does not distinguish between party potions and sua sponte sanctions in the same way Rule 11 did when the case was decided in 1998. Our flip did not even exist at the time, and it allows the same form of sanctions regardless of whether the sanctions are upon motion of a party or the court's own initiative. Barber tells nothing meaningful about Rule 26 in this context. Clayton asserts the notice he gave in his motion for leave to amend and the amended response complied with Rule 26. The amended response specifically identifies the pleading and conduct that he believes violates Rule 26. Clayton filed his motion for sanctions separately several weeks later, long past the 10-day safe harbor period Laura claims she did not receive. In Holgate, one of the parties, the Newells, has their sanctions award upheld on appeal despite not sending separate notice of their intention to seek Rule 11 sanctions. Instead, they filed a motion to join in the sanctions motion of another party and serve their joinder motion the same day they filed it. The joinder motion was the first motion the opposition had of their intention to seek sanctions against him. So many motions in 26. There's just a lot. The motion that's a motion that's a motion for the motion. Okay. They filed a second motion requesting sanctions months earlier. The Holgate Court found the safe harbor period commenced when the Newells filed their initial joinder motion, and the second motion for sanctions supported an award of sanctions. In summary, because Levinson had prior notice of the frivolousness of the complaint from the Baldwin motion and notice of a second forthcoming motion for sanctions, we conclude the district court did not abuse its discretion by awarding sanctions to the Newell defendants. I'm sure Gingras writes back, rules doesn't apply to us, only to you, period.
I know it sounds like he's got a lot of rules for other people. So,
right, that's right. 111 chat, only 56 likes. I like it. And a Llama gets a gavel, and a Terry gets a sparkle. We need to give something for Buffy with a like too. I have to think about it. Now, nothing in Rule 26 suggests the safe harbor notice is not satisfied by filing and serving an earlier motion that provides the opposition with notice of the conduct alleged to violate the rule. Rule 26 does not reference a form or provide specific language that must be included in the notice, like many other rules and statutes do. Rather, it requires the party to be sanctioned has actual notice of the alleging offending conduct and an opportunity to withdraw or correct the filing, right? So we're going to tell you that Laura is a fabricator, liar who lies, who submitted fraudulent claims, and then she has 10 days to be like, yeah, no, all right, I'm done here, but you still get to apply for attorney fees, right? That's what I'm understanding this rule to be. And they did give the appropriate time, but even if they didn't, it doesn't negate that, I think.
I'm a little disappointed in this motion. I needed a little more fire.
Well, I think there's fire in the emails. If we get to them today, I don't remember. I think his legal strategy is to bore people into not caring. Yes. Yes. Gingras, rules for thee and not for me. Also, Laura's golden rule. Obviously, because they're perfect. Now, Laura's present day assertion that she would have withdrawn her petition upon receiving Rule 26 notice is not persuasive of anything because her actions would not have changed whatsoever. She was not prejudiced. She asserts that she did not receive proper notice and therefore had no opportunity to withdraw her petition. But the fact she changed position in response to the motion for leave to amend by moving to dismiss her petition, albeit after the 10-day window before Clayton could file the motion for sanctions. Laura was not prejudiced because she would not have done anything differently had she received a separate notice in whatever form she believes would have been proper. She had actual written notice, changed position in response to that notice, an attempt to withdraw her petition, and the court denied her that relief because it must resolve Clayton's claims before disposing of the action. So even if the court finds Clayton's notice insufficient, the remedy is to deny the request for sanctions based on his Rule 26 motion. Rule 26 sanctions for improper procedure in seeking Rule 26 sanctions would create an illogical cascade of motions and counter motions akin to two mirrors facing one another. Which I don't know if that's what we have coming, right? But I feel like that's exactly what's going to start happening if you ask me. But me, you.
It's the Spider-Man meme. You, me.
Now, nothing in Rule 26 would prevent one, Clayton issuing a new notice and filing for sanctions after the new 10-day safe harbor period. Two, the court issuing sanctions on its own motion, which the rule expressly allows. Three, Laura filing a motion for sanctions if she believes one is appropriate after following the procedures. Or four, the court awarding attorney fees, costs, and other appropriate awards under any of the numerous statutes allowing or requiring such relief with no relationship to Rule 26. Indeed, the court must resolve the statutory claims for relief, notwithstanding whether Clayton or Laura ever filed anything pertaining to Rule 26, and the denial of Rule 26 sanctions has no impact on the substantive claims the parties have brought. Okay, we're almost there, guys. We're almost there. There's only 2 pages left of this. Ultimately, and then we get blogs. So stick around for Jingers' unhinged blogs because it looks like they're going to be crazy. Ultimately, although Clayton believes he complied with Rule 26 and that the court already overruled Laura's objection, it is clear she intends to continue her established pattern of threatening her way through litigation, refusing to comply with her discovery obligations, and seeking to avoid the merits of this case through any means necessary. Clayton's claims for fees and sanctions exist independently of the Rule 26 motion and have already been set for trial. With or without the Rule 26 motion, those claims require resolution, as the court already found when it preserved them while dismissing Laura's petition. Clayton would rather avoid the $35,000 slideshow. Spoiler alert, it's going to be fucking a lot more than that. Like $100,000 more than that. Sideshow Laura intends to use to distract from and avoid the merits of the claims against her. Because the Rule 26 motion is not the substantive pleading basis for his claims against Laura, there is no reason to participate in the pointless litigation of this issue, notwithstanding Clayton's disagreement with Laura's position on Rule 26. Subjecting the court to this collateral chaos, which is intended only to increase legal fees and prevent resolution on the merits, would be a waste of judicial resources. Moreover, Laura's threat to seek personal sanctions against Clayton's counsel based on her proffered Rule 26 violation, while considered frivolous, will only draw more attention and animus to this case. Without the Rule 26 motion will not affect the court's duty to resolve the claims Clayton properly brought under Title 25. It will, however, prevent the wholesale wasting of judicial resources and attorney fees on this meaningless procedural issue. Accordingly, he moves to withdraw the Rule 26 motion for sanctions. He does not withdraw his counterclaims for a finding of non-paternity attorney fees, costs, and sanctions, and any other relief appropriate and available to him. Oh, we did it, you guys. We did it. Oh, and there's a verification in case, that way everybody sees that. We need that. It's very important, I guess. All right, I got to let Zoe out real quick before we move on to the next one. Good Lord. So they're dropping this because they're like, we don't even need to fucking talk about this. All right.
Mhm.
So we'll just get rid of it. We don't even need it. It's fine. Just let's stop wasting time on some bullshit, Jingris. Is basically what that was about. Hold on. I'm going to go.
That was a lot of words.
So many words. You're reading the blog, by the way.
I don't. Oh, that was a lot of words for no reason. I feel like we should have a character or like at least a word limit on this stuff because it's way too many words just to ask for like a withdrawal. And yes,
I think
like Jinger should be capped too.
Well, because we do know the future in that he is facing like a bar complaint or losing his bar license, possibly. And I saw somewhere where like they have like a page limit when you file.
Oh no, he's not gonna make it.
Yeah, I hear that he complains about it a lot. And that he'll just like do whatever the page limit is. I don't know what it is. I'm just making up the number of like, let's say 28 pages or 30 pages or whatever. I don't know what it really is.
Oh no.
He'll file like one to get like an extension of or to be allowed to file more pages I know
Oh
there's
my
one where he
God.
asked that. Like,
That
and he'll file like 3 of them. It's crazy.
no. Oh my gosh. That doesn't really surprise me at all. That doesn't really surprise me all that he would need to have more time, or at least more words and more pages. Oh my gosh. So I don't think I have access to your blog.
Oh, here. Well, hold on. Zoe might be coming back inside. I don't know. Maybe she's going to lay outside, or they're going to sunbathe, or. Oh, nope. She's just going to look me in the eye and just head to the backyard because that's what she does.
Good morning, Lainey.
Okay.
He should not let ChatGPT write it. Have you seen how wordy ChatGPT is? Like, there's so many unnecessary words in anything ChatGPT writes.
That is true. Good Lord. I better not have to say fucking Rule 26 another time today.
I think we probably will.
Probably.
Let's see. What is on the next one?
We got, I'm coming back. She'll scratch at the door when she's ready, or she might lay outside. Who knows? Okay, here we go. Here's that one.
It's
the camera.
His same blog post on this same day.
Yes.
April 23rd.
Let me make this a little bit bigger for us because we don't need the side nonsense. There we go. Oh, lettering is so light. It's annoying. It's fine.
That background.
I know.
It's I only do dark mode. I live in a cave.
I agree. It's annoying. You can't just like make everything dark mode. Or can you? And I just don't know about it. Probably that one.
I don't know. If you figured out, let me know. I feel like I'm starting to become my mother when it comes to computers.
Me too, girl. Me too. All right. So on to David's blog. I'm sure this is going to go over very well. I'm sure it's going to be very respectful and adult-like and make a lot of sense because I know when you go to fight with people on the internet, it always goes well.
Yeah. This is okay. So this is Jingris's response to after.
I don't know.
Like, did he get the note? Okay. So, okay. I didn't know if maybe he saw the motion first.
I'm going to go with respond. He has 2. We're reading 2 of his blogs today, again on the same day. So I don't know if one's before, then motion, then after, or one's they're both. Who knows? I don't know what we're getting into here. I have no idea, except that he writes a lot.
Okay. Well, that's literally how he starts the blog. Some comments on today's Bachelor news. Okay. Woo. No more 140 character Twitter limit. That's funny. We were just commenting on that. Not gonna lie, trying to explain complicated legal issues in such a limited format was getting tedious. No mas. Let the word salad start spinning. I appreciate his what is the word I'm looking for? Like, he knows.
Awareness. Self-awareness.
That's the word. See, apparently I'm not aware enough to use self-awareness correctly.
See, we were just talking about how when people have it, though, doesn't mean they use it.
No, but I think
that's what we're going to get here.
Word salad. Like, we know. Yeah. He knows that he's just going to start saying shit. And yet he continues, but that's funny. All right. So to begin with, I want to clear up a few things first. First, I've seen some people questioning my professional qualifications and implying that I am some kind of fly-by-night, low-rent Saul Goodman.
Low rent? Oh, that's very specific. That is oddly. Did somebody say that to you, David?
Man, that was such a miss on today's thumbnail because I could have just put the card up there that said "Better Call Saul."
Don't worry, we have plenty more to make over time. So
Har, kids. If you knew what I knew, you'd punch yourselves in the face for being such idiots.
Shut
Let's
up.
get that out of the way right up front.
You punch yourself in the face, idiots.
Stop hitting yourself. Stop hitting yourself.
Oh, wow. Okay. All right. This is going very
Yeah,
well for us.
He did come out the gate, right? I graduated from law school, University of San Francisco, in May 2000. Oh, I was a senior. I took and passed the California bar exam first try.
Wow. Good job, David.
Then I moved to Arizona and took and passed the Arizona bar exam first try.
Gold star for you, David.
Okay, good job. At this, has anybody got the David counter going? Do we need to have that in the side? Oh, Lord. Okay. At the start of my legal career as a young lawyer, I worked for a small 5-lawyer firm in Tempe. 2 lawyers in that firm handled nothing but family law cases. So I got to do tons of fun stuff like divorce, hell, child custody, nightmare, child support collections, cha-ching, all that crap.
Oh.
I'm sure your clients appreciate that. Referring to their life-changing cases as crap. But, you know.
Classy.
I have
classy, David.
But Llama, he has respect for family law attorneys.
Okay. Sounds like it. Okay.
But it's not his thing. Seeing people go through a divorce, always accusing each other of some terrible shit, never thinking about the kids. It's not fun. He may not have morals, but he's got standards.
That's true. I mean, family law is disgusting. It gets real nasty. Real nasty in there.
We're talking about Gingras. It sounds like it's very fitting for him.
That's true. Yes. That's true.
In the mid
family
2000s,
law attorneys, because I couldn't imagine dealing with that bullshit just every day of adults being
That's why you always talk to their paralegal.
Right.
I know that's who I always ended up talking to.
Oh my goodness.
In the mid 2000s, I moved to a larger firm in Phoenix, about 35 lawyers. Still did some family law, including trials, etc. One day, I saw a lawsuit on my boss's desk with the name Colin Farrell listed as the plaintiff. Is that the Colin Farrell, the actor? I asked.
I think so. Oh, I just realized that was part of the block. I was like, yeah, I think so.
He writes it like a novel, like he's writing a novel. Yep, replied my boss. He made a sex tape with a Playboy bunny and he is suing to keep it out of the public eye.
Oh, okay. Yeah, I remember that. You remember that?
No.
You don't remember? Okay.
No.
I remember.
I don't follow celebrities.
You don't follow celebrity sex tapes? No, I'm just kidding.
No, it's not really.
It was just like one of the it was just like one of the big ones that like came out.
Was it in 2000?
Yeah, like in the
okay, well, I was too busy whoring around with my boyfriend at the time.
Oh, making your own
I wasn't paying attention
okay.
to that. Probably.
No. But I thought it was with what's her name? Naomi.
Girl, I don't know.
Campbell. I thought the sex tape was with her, not a Playboy bunny. I don't remember. It's been a while.
Anyway, now I don't know where I'm at. Okay. He's suing to keep it out of the public eye. Okay, screw family law. That is the kind of case I wanted to work on.
Of course.
So I jumped on board, went to work like crazy, and learned the ropes of big-time litigation. I eventually got to meet Colin Farrell when we took his deposition in New York on Easter Sunday, 2005. We eventually settled that case, and I got to have lunch with the guy. Way nicer than you'd expect if anyone cares. This was part of the legal proceeding. It moved from state to federal to state court and was eventually settled.
Oh, I have a question for our smart friends. All right. So now that we know he has his license in Arizona and California, and I know that he's dealing with the bar right now. Is that Arizona bar specific, or does it apply to both California and Arizona? Like, if the bar
Hmm.
does it take away all your licenses everywhere, or does it, like, is it
I would
specific
think it would
state by
just.
state?
I would think it would just be state by state.
I never kn I
I
don't
don't
know.
know. I don't know
Somebody
any
give us
enough
the
about
answer.
it to have a comment.
Smarter than us, somebody. Hmm.
If you know the answer, put in the chat or write a comment. But I would think it would just go state by state.
It is. But sure, this has everything to do with The Bachelor, just as much as the Trump v. E. Jean Carroll had everything to do with
I don't
Owens
think this
versus
has
Echard.
anything to do with The Bachelor. I just think he used it as the title. I think this is the clickbait title.
Mhm. Okay, so it is state by state. Okay. All right. Wasn't sure how that worked.
This is all about Gingras. Because we need an introduction.
If he's sanctioned, there's
apparently.
a chance that California will take notice. Oh, okay. You guys are so helpful and smart. Love your big, beautiful brains. Okay. Sorry. Go ahead. Tell us more about his greatness.
Stroke that ego. This started my career in what I call internet law.
Oh,
Did he
okay.
make that up?
I think so. I've never heard of internet law,
I have no.
but okay.
Maybe
Like
there is
bird
such
law?
a thing, and I just never heard of it. Was it bird? You said bird law,
Bird law.
like tree law,
Llama law.
arbor law. Well, they have
I-
all kinds. They have like canon lawyers. They have arbor
that's right.
law, like tree
We for-
lawyers. Like there are things.
Tree lawyers.
They do. Have you
I
ever cut
know.
down your neighbor's tree? I have never, for the record, cut down a
Mm.
neighbor's tree, but don't mess with the arbor law lawyers. They will come
They'll
for you.
get you. All right. I love that.
I'm just saying.
I'm gonna have to look into all the different kinds of laws.
Go into TikTok and all these people who cut down their neighbor's tree. Whew. Tree law
Yeah.
is a thing. Yeah, I
Yikes.
get weird rabbit holes. Anyway, so what this means is that most of the time I handle cases involving people getting sued over something posted online.
Hmm.
This frequently involves defamation claims, but can also be stuff like copyright infringement, trademark infringement, or any other claim arising from content posted online. That sounds like a threat.
Oh. So, okay. Noted.
I sometimes handle other stuff, suing people for money, etc. But
Oh.
most of the time is spent on internet law cases.
Internet law.
It's a veiled threat, just so you know. Like,
Mhm.
I sue people over what they post online. Make a note.
Cool. Okay.
Over the years, I have handled hundreds and hundreds of internet law cases from, I can't read past the llama.
Oh, sorry. Oh,
From the 2009 to 2014, I litigated a crazy matter involving a Cincinnati Bengals cheerleader that almost went to the U.S. Supreme Court. I handled 2 jury trials in that one, and eventually we won 100% victory on appeal. This
Okay.
was and still is regarded as one of the most important internet law cases in the last 20 years.
Oh,
If you
thank
really
you,
want to read
Terry.
about the case, he's going to drop his link here so that you can read about it.
Thank you for gifting 10 memberships, Terry. Congrats to all of our new members. We have a lot of member-only content, so lots of stuff to keep you busy when we're not live, which is sometimes happens. I feel like we're always live.
I'm hiding behind the super chat.
You are? There you go.
I was
There
doing it
she
on
is.
purpose, trying to hide. I've handled tons of other high-profile matters. Back in 2015, I defended a lawsuit brought by the king of Instagram.
Who's that? I don't even know who
dat?
the king of Instagram is. I didn't know there was a monarchy over there.
I didn't either.
I'm
Dan,
such a peasant. I
name
don't
is
even have it.
Dan Bilzerian. I've never heard of him. So if he's the king of
Bilzerian?
Instagram,
That
who's
sounds like you have like a billion. I'm a bazillionaire. Bazillion.
I don't even know who that is. He
Bazillion.
can't
I don't
be.
know who that
He can't
is.
be that like kingly if nobody knows his name.
Right? Who's that? Oops.
Well, if you want to know, he put the link in there for you. More on that
Oh,
case here.
oh,
Total
oh,
douchebag.
total
And that's
douchebag.
coming from Genius.
We'll open that link up for later. See who that guy is.
In 2016, I was hired by none other than fucking Johnny Depp.
Really? Really? Okay.
Was he though?
Were
I don't
you?
know.
For what?
Okay.
Let's find out.
As part of his breakup with Amber Heard. Can you see him up there with Camille Vasquez?
No, he wishes. He wishes.
I wasn't involved directly in the divorce, and I did not directly represent Johnny. Then what did you do, sir?
That's like saying, I have my billionaire tech boyfriend.
I know he's doing a lot of name dropping, isn't he?
Yes. God, there's so much alike. It's
Right?
crazy. Wow. Okay.
Yeah. So I wasn't involved directly in the divorce, and I did not directly represent Johnny. Instead, Amber Heard sued Johnny Depp's best friend here in Arizona over this article slamming Amber. Notice how that article is still online? Yep, because I kicked the shit out of Amber's lawyer in court, and she dropped the case about 2 days after she filed it.
I did not know we were in the presence of royalty over here.
We are.
My goodness. Presence of greatness.
So he was hired by Johnny Depp, fucking Johnny Depp, to like represent his friend. So it's like my best friend's friend's cousin.
Grandma
Is
that,
Johnny
no.
Depp. So like
I love
basically we're besties.
Right? Tug would know that. That umbrella guy. That's true. He's
Okay.
all over that case.
I can give you more examples. Go ahead.
Okay, please do. Betty
But
will.
you get my point. I'm sure he's
No.
going to drop it. He's going to
We
drop it
need
in there.
more, David. Give us
I
more,
want the
David.
whole resume.
Sure, it's a
That's
story
a
for
joke.
another
Please
time.
don't send me your resume. If you think I'm not a lawyer to take seriously, you will quickly learn otherwise. Bum, bum, bum.
Dun-dum.
And yeah, my style is a little harsh, but I do try to treat people with respect until they no longer deserve it. You know?
Okay. Do you respect us, David?
No offense, David. I don't think
Okay.
you're as respectful as you think you are. Now, enough about me, I'm sure. Let's talk about this crazy Clayton/Jane Doe case.
Finally. That's what you titled it. Jeez. Okay.
And by the way, I have absolutely no idea why people think they aren't allowed to say her name. I can't, for the life of me, wonder why. They think they can't say her name only because she cries about it on the internet. I don't know, man. I don't know.
Dogs. Right?
It's like she just cries and sues people for talking about her. I don't know why I can't say it. He said, say it. Her name is Laura Owens. Oh my gosh. Don't tell me he's trying to be like, say her name. There is no court order restricting the publication of her name. And it is not illegal for you to talk about her. But she will make you think that it is. Looking at you, Dave Neal. What is that supposed to mean? What is that supposed to mean? How's he look like pointing the finger at Dave Neal when it was like her going after him for talking about her? Oh man, these people talk out of both sides of their face. Oh my gosh. I absolutely believe you. I think he does. He watches too many TV legal dramas. I think he thinks he's like on like, what is it? Law and Order and stuff. Like he's awful. Like, I don't know. He's dramatic. He's worse than she is, I think, sometimes. Anyway, so let me get where I'm at. Dave Neal. Oh, and for some of you special ed folks, oh, yikes. Oh my gosh. Did he really? Did he really? Oh, that's hurtful. I have a special ed son. That's not cool. It is so not cool. I hope they dragged his ass for that, because that actually makes me mad. That actually really makes me mad, because that's uncalled for. They should, because yeah. Okay, so that word gets on, like, pisses me off a lot. And I hear it from kids like my daughter's age, and I will slap my kid. She knows better to say that around me, because her brother is, was developmentally delayed. So, like, we don't do that. We don't do that. He's doing much better now, though. Let's see. That's not cool. Jingers, it's not cool. Actually, yeah.
What?
Did you hear that?
Yes.
He used special ed.
I couldn't get
and
back
used
here.
Special ed.
I couldn't get back here. Right. Oh, that's not the right one.
You're such a dick, David.
Yeah. You're such a dick, David. Okay.
He's messed up. Look, it's like
out here.
The chat. My kid, like, was
Mm-hmm.
cool. I don't like that word. That makes me mad. That makes me real mad.
Oh boy. Oh geez. Okay. Okay.
There was no
Wow.
need. There was no need for that. You can call people stupid without, like, come on now.
Where are we at? Am I not caught up with this?
No, you're fine. Keep.
Oh, was I?
You're up
Okay.
there. It's a top paragraph. Because
Oh,
he just. What?
Oh, there, I see it now. Oh, that was only
Yeah.
the first paragraph while I was gone.
Yeah, because I was ranting
Dave.
because he sat there and said that you can say her name, and then he told Dave Neal that, like, oh yeah, whatever, you can say her name. I don't know why you think you can't, except she's the one throwing the fit because Dave Neal was talking about her. So I don't know.
Right.
He's just, these people talk out of both sides of their face. I don't get it. I don't know why he thinks he can't. No, I was ranting for a while about the special ed crap. So
Well,
sorry, chat. No, there is no court order limiting Laura's right to publish her own medical records. Seriously, try to at least have a third grade. You could put the RD after 3. A third grade level you could write at a third grade reading level. Everybody knows to put the RD after. Come on, man. Right. No, there is no court order limiting Laura's right to publish her own medical records. Seriously, try to have at least a third grade level comprehension of how the legal system works before you start claiming to be an expert. You look stupid. Stop.
David, why are you so angry, David? Why?
I think he needs a hug. Did he not? Did his mother not love him enough?
I don't know. Like, what are we doing here,
this
David?
sounds like a man who did not get loved enough as a child.
This is embarrassing for you.
No offense, David.
Yikes.
You're kind of an asshole.
Yikes. Yikes. This is his first blog post we're reading. There's so many more, Buffy.
He's out the gate. No, like I'm already angry. Like, I do like sass, but he's like, this is just mean.
Mm-hmm. Dick, David. You're being a
He
dick.
just came out swinging, and he doesn't care who he hits. Now, as for the case itself, this is where I'm going to be more careful. Really?
Oh, that's where you're gonna forget about the offense I've caused people. I don't give a fuck about that. I'm gonna be real careful here.
It is. Stop. Read the next sentence. It is not appropriate to try a case like this in public. And yet here we are.
David, here we are.
Okay. I can't share every fact and detail with you because the rules don't allow that. And it wouldn't be fair to Clayton.
Right.
Or you don't have anything.
Right. You seem like a guy that's all about fairness, but okay.
Oh, okay. Because I'm sure he's worried about Clayton's well-being.
We're going to get more Buffy rants. I love that for us.
Yes, I know Laura already went public with way too much info. And yes, I know Clayton tried to walk back with his. Does it say walk it back? I can't read. It's in the
Oh,
couch.
I'm sorry. I thought we
To
were on the
punch
underneath.
back with his own press release. They were both dumb to do that. Or at least it's not what I would recommend. Really? You recommend Twitter?
Yeah, and let's do
Sounds like a
trial
better
by
plan.
internet law on Twitter X, the best place to do that. Okay.
Also, yes, I'm not fully up to speed on everything. Then you should probably sit down.
Sit down, David. Sit down.
He said, stop reminding me of that. I know it. I'm working on it. It's just cleaning my room, Mom. Jesus. He's such an idiot. Give me a effing chance. Give me a fucking chance, guys. It's barely been a week, and this is not my only case. When?
So it kind of seems like it is its only case. How do you have time to write all the shit you've already written and have other cases? It's wild, but okay. All right.
Having said that, a lot has happened in this case over the last 8 days since I got involved. I am going to post a few more comments about this moving forward, but only because I actually want you guys to be informed so you can speak intelligently about this stuff.
Yeah.
Because you're stupid. Because you look stupid. I don't care. Not even the slightest, whether you love Clayton, hate Laura, or indifferent.
Okay.
Yeah. You know what people do who don't care? They write blog posts about how much they don't care.
That's true. They do. Long ones as well. But sure.
Everyone is entitled to their own opinions. Don't care which side you are on.
Oh my goodness. Okay. Don't care.
What I do care is that you have an accurate. Stop. I know I don't know everything that's going on in this case, but you need to be accurate in your understanding of the facts. But I have no idea what the facts are. But you should definitely know what you're talking about. This guy. Okay. You should have an accurate understanding of the facts. And if possible, I want you guys to understand how the law works. Because Jesus fucking Christ, Paul. I'm sorry, I couldn't help it.
Paul.
This group needs some serious help in that department. He's talking to y'all. He's talking to you.
Yeah. You guys, not us.
All of you guys.
We don't have all the facts, but we have enough to talk about it.
You need help.
According to him, it's fine.
You need help. All of you need help.
Idiots.
Get some help.
Okay.
Oh my God. And he doesn't, by the way, he does not mean that disrespectfully. I don't mean that disrespectfully, guys, but get some help.
Right. You could word it like a different way, David. I don't know. You chose those disrespectful words to say to people, but okay. Tell us more, David.
Right. It's more about him.
Oh, okay.
Before I was a lawyer, I worked at fucking Taco Bell. For Pete's sake.
That's our fault. That's our fault. We said we wanted his resume. We understand. That's our fault there. Yep. We apologize.
It's true. We did ask for his resume.
We apologize for that.
Good
but
Lord.
Also, okay. And
how long did you last at Taco Bell? I'm curious. David, can you leave the comment? I know you want to answer this question. All right. And I, too, did not know a freaking thing about this complicated, messy system. It takes time. So please try to realize that maybe you don't know everything. And maybe you should ask questions before rushing to a conclusion. You may just learn something.
Oh, we might learn something, Buffy. Are you ready? Are you taking notes?
I'm still trying to figure out what Rule 26 is.
Are we going to get a
and
quiz,
rule
David?
29 and rule 11.
He's like an angry gym teacher.
Right?
Yeah, if you see, he kind of looks like a gym teacher too.
Oh my God.
Yes, you should put him in like those short gym shorts.
No,
for one of our
nobody
tournaments.
wants to see that, Llama. Nobody wants to see that. Oh my
Oh, goodness. Okay. Who's going to tell the girls about what he did at Taco Bell?
What did he do at Taco Bell?
Oh, what does that mean? I don't eat there anyway, but
Okay, well, now I
still.
need to know. I'm going to need someone to spill the tea. What happened
Oh
at
my
Taco Bell?
goodness. Okay. I'm sure he'll tell us. All right. Let's find out more.
Okay. This post is already too long, so let's leave it there for now. We can talk again soon. I will update when/if necessary. Not because I want to earn the big bucks. This page is not monetized, and I'm not charging Laura for writing this. This is purely a public service message.
Shut up, David. Shut up. The police didn't ask for this, David. And this is because I'm a good person. And I'm letting you all know this for free to educate you fucking idiots.
Oh my God.
Oh my
Until
gosh.
then, please stick to some basic ground rules. He's going to give us the rules, guys. There are rules.
Okay.
It's like the scary,
Are
like
there
in
26
Scream.
of them?
Like in Scream, this is the rules. You got to, there's always rules in a scary movie. This is a scary movie.
Did Loud Little Ducky put him in gym shorts and sneakers? I hope she did.
Oh my gosh.
That's
Nobody
where
wants
his
to see that.
underage victim worked.
Wait, there's an underage victim? I am so behind.
He was indicted with CSA with a young Taco Bell girl?
No.
David. Oh, that's not great for you, David. Don't like
dirty
that.
raccoon, David.
Yeah, David. Big dirty raccoon. What?
Oh my God. I'm sorry. Wow.
It's just always so much stuff. Always crazy shit happening. Extra things happening in this story. Oh, David.
I feel like there's so much lore. There's so many side quests. There's so many onions. Like layers, onions. You just peel them back. There's more shit.
And lots of tears. For sure.
Oh my God. It's true.
Oh boy. Okay, so what are the rules, David? What are the rules we have to play by? Because you're a stickler for
You
this.
can ask any questions you want.
Okay.
But you have to be nice.
Oh.
And respectful.
Okay. I don't think those words mean the same to him that they mean to us. Because
no.
there's a lot of not nice or respectful language, David.
Yeah.
Okay.
I'm getting too old to tolerate pricks. So don't be a prick. Don't be a prick, Llama.
The word prick doesn't get used enough, I think. But also, wow, sir, that's okay. Don't be a prick.
That's the public service message, guys. Don't be a prick.
Don't worry, he's not
And
charging us for it.
And I will do my best to reciprocate. He's going to really try not to be a prick. You don't be a prick, and he'll try his best not to be a prick. You see how
Do
that
his
works?
Best, but
He'll
he can't
just
make
try.
promises.
You
Can't make
can't be a prick, and he'll just try not to be a prick.
Wow.
Pricks and people acting in bad faith will get blocked.
Okay. Interesting. Okay.
All the others are welcome to talk, though. More to come soon. Oh my God.
Wow. Wow. That was not disappointing at all. His case got thrown out on technicality because the DA was doing something wrong on another case. Oh, that's probably why he's such a stickler for all of that.
Oh
now.
my God.
I need y'all to end this stream. If podcast work to do, y'all are getting in my way. I know. We're the worst. There's a police
such
report.
pricks.
I'm going to need to get that. I'm going to need to get my hands on the police report. Because I didn't have that on my list of my freaking 10-tab spreadsheet I have for this damn case. What? David, what was this about? This is rude. This is, I don't know. Maybe, does he understand the saying, just because you can doesn't mean you should,
No.
David? And this
No.
is one of those things. Probably shouldn't do it, David. You can't change people's minds on the internet, David.
But he's going to try. And
this
he's
his
going
first
to
day?
he's going to insult everybody while he's doing it.
Exactly. And then be like, but don't come at me and be a prick. Only I can be a prick. Okay. Wow.
Well, he'll try
Wow.
not to be if you don't be.
Ooh, we got a comment. Jane Doe. Where are the fetal death certificates? DSG, there is info about the end of her pregnancy that is documented with medical records. Situation did not require a fetal death certificate. You are being fed a line of bullshit by people who are selling half-truths for clicks. Sad and fucking sick to exploit this situation for ad revenue. But that's life, and it's what scumbags do, to be honest. Just wait for the trial. It will happen June 10th, and you will hear everything you need to know by then. Laura, is that
Laura.
you?
Yeah, that's definitely Laura.
Okay, Laura.
Also, I love how I said Jesus Christ, Paul, and literally the next comment is from Paul.
Oh, yeah. Thank you, David. Who's Paul? Does Paul reappear in comments? I love comment sections a lot, especially when like they tell you can track a story through them. You have reoccurring characters in comments. I don't know if this one does, but it's my fave. So you did ask if there was backlash for
I did, because that was shitty ass comment.
And I had it pulled up.
Everybody called his like, I'm mad about that. Like, that ticked me off. I hate when people do that. Why do they feel like?
Okay. So this is from All the Best Research, who have a freaking fantastic timeline. I mean, Volo is a good timeline as well, but they include a lot of All the Best Research includes a lot of the social media stuff and the stuff that went away, which is nice, where the Volo is mostly like legal documents and stuff, which makes sense. They're both fantastic resources to use. So somebody on Twitter says to him, as a special needs mom at David, makes me absolutely sick. He's revolting. I can't wait to see his sorry ass lose in court. I agree with you, Mrs. Brightside. And then David said, also, just so I understand, you are a special needs mom who is attacking a guy you have never met on social media. My crime? I defended a law that allows people to, among other things, attack people they have never met on social media. I concur. You do have special needs. David! What a dick, David! Wow. But then you get all fucking butthurt about people being pricks to you on the internet. Wow.
Oh, no, David.
Yeah, no, David. Very ew. Very ew. Very not cool. So Miss Brightside responds back, no, sir. I was referring to the comment you made on your blog post where you use special ed in a derogatory way, which you also did just now. That's incredibly insulting to kids that use those services. Oh, lobster claws. Lobster clap for Mrs. Brightside.
It's not lobster claws.
It's
She's
lobster
so
claws.
cute.
Looks like I'm
You're so pretty.
I know, right? So David comes back, says, Post has been updated and prior rude tweet removed. Life is hard enough and kids can be horrible to each other, especially if a kid is different. As a small apology, I'm happy to send you a gift card to take your child to pizza or whatever. Contact me directly if interested. David! You know that those special needs kids grow up to be special needs adults, right? Like, it doesn't really matter about it's the whole community there.
Bro, this was not no. Shh. There are times where you can just not talk and you can just type 3 words. I'm sorry.
Yeah.
Yeah.
And you're
You don't
right.
have
Life
to
is
bother.
hard. And kids, people can be horrible to each other, especially if a person is different, David. All right. So you know the
Wow.
right way to act. But then you're just like, oh, you know what? I'm not going to act that way unless somebody calls me out for it. Do better, David.
Isn't Laura claiming to have all the things? You have a special needs client?
Wow. I mean, you know what? Thank you for resending that. But also, what the fuck, David? So then David
Oof.
says, replying to at Brightside, at Woodnick Fan Club, and 11 others, because I'm sure the internet had things to say. And because I'm a decent person, a little mouthy, but still decent, I will respond to that as follows. You are 100% correct. I agree that statement was inappropriate. All kids need love and support, so I truly do feel regret for what I said. I will remove that right now. All right, fine. Cool. Glad you removed it instead of just fighting it. But also, just because somebody called you out on it, David, come on. You use that kind of language to knock people down, to punch down, David, to punch down. You knew better when you wrote it. So you get half a third forgiven for going and fixing it, because some people on the internet would never do that, to be quite honest. But the internet never forgets, David. They never forget. Wow.
It's still on the one we read, so clearly didn't fix it.
Oh, that's because it was the archive, the original one.
Hmm.
Because all the best research archived all of his. Some of they aren't even up anymore. They archived them all.
Well,
in their
good.
original-
Good.
Because the fun
Good.
thing is too, as you can see, by the way, this is the all the best research site. There's another thing that they do where they compare the originals, because so here, as you can see, they or he replaced special ed folks with Clayton fans,
Oh.
which is, I don't know, better,
Oh.
I guess. I mean, still, okay.
What's the implication there?
Exactly.
Yeah.
So how do I make this smaller? What happened? I don't. Anyway, like I said, it's a very, that website's crazy,
Whoop.
by the way. Oh, okay. But like,
I forgot I don't have control over your thingy. I'm over there trying to help you. I can't do anything.
oh, that's because it opened up a whole tab. Oh my gosh, I'm so silly. Let's see. Okay, so that was the end of that. So what does he do? After that, he writes another blog post the same day.
Of course he does, because that's
Of course
what
he
you do.
does. This one called.
He's feeling himself.
Oh, I guess I'll try again. Does David do better this time?
Oh, do I get to read this one too?
Sure, why not?
Because you like to listen to me. Why not? I can give you a reason.
Those are reasons aren't good enough. Go for it.
Hello and warm welcome to all 3 people who follow this page. Peace be with you. Everybody also
Peace
with
be
you,
with
right? If you're
you.
Catholic, you know how to respond to that. I've
And
moved
also
off
with you,
Twitter.
David.
That's
Oh.
also with you. He's moved
He's moved.
off Twitter.
This is the
Did
same
he get
day.
Yeah.
I
get kicked off
decided,
Twitter?
did you get kicked off there, or were you like, fuck, they hate me, so I'm just gonna remove
But
myself
how
'cause
many
they didn't
times has
like
he
me?
moved off Twitter?
I
Like,
guess
is
for
he
us,
one of
this is
those people
number
that
1.
are like, is he like one of those people that are like, I'm gone. I'm leaving the social medias forever.
Yes.
And it's like 5 days. And then
I'm
they're
so
like,
over
hey
this
guys, I'm
bullshit.
back.
Yeah.
Mm.
I'm gonna live a happier life. Yes, that is exactly what I take from this guy. My chair is sunk all the way down. Look what you've done, David. Look how short I look now, David. It's all your fault. Beating me down, punching down at us. Just a lonely peasant.
Sink,
the king.
sank, sunk. Oh, Lord.
Oh, yeah, update.
Okay.
He's back as of yesterday. As of this past
Yeah.
week and yesterday and all the days. He can't quit us.
Oh, he likes the attention, even if it's bad attention. So I've moved off Twitter. Fuck you, Elon. And my
Okay, Brittany.
first
Okay.
Okay. And my first non-Zitter, ex-Zitter post wasn't really about the Clayton Echard case. No. I promised I would say more when I could. So let's do that.
Fantastic. Let's
All
do
right,
it, David.
Yeah, let's say, let's go. Let's go. A lot happened today. So let me see, I read that as let me mansplain this to you, but it clearly does not say that.
Dear
And he's
Internet Diary.
Because he's not that self-aware.
The Twitterers were mean to me today.
Yeah.
I'm going to try again another day.
Because it wasn't like I
them.
launched the attacks first.
I hate them, and they're all fugly sluts. Internet Diary. All
Put
of
it
the
in the book.
Twitterers.
Let me hand you
Put it
the
in the
burn
book,
book.
David.
A lot happened today, so let me explain. Earlier today, Clayton's lawyer. He did read the motion first. Filed a motion asking to withdraw a motion for sanctions. He filed on January 3rd, 2024. Here's what he filed, and I guess he links it to the motion. Okay, what does that mean? How does that affect the case? Does that mean Clayton lost? What's going on? I'm so glad we have you to explain this to us.
Whew. Thank goodness, because I'm just a dumb woman who doesn't understand. Thank you, David.
Stupid.
Thank you.
We are all stupid.
Idiots.
True answer, it actually does not matter that much, but let me explain. The timeline of this is important, so let's recap. My client Laura filed this paternity case on August 1st, 2023. Clayton filed what is known as a response. I don't know why it's in quotes, because that's what it is. It's a response. Like, I don't think you know how to use these appropriately. On August 21st, 2023, his response basically said, "No, I'm not the dad. Let's get a test and confirm I'm not the dad. And this will all go away." See, I just have a picture of him writing it. Like, I know he's like making the voice, moving his hand. Anyway, that is standard stuff. In late September or early October 2023, Laura and Clayton submitted samples for early testing. Those samples came back inconclusive. Even he's using in quotes, inconclusive. I don't think you're doing that right, David.
God, David.
What an idiot. Laura claims she had bleeding in mid-November 2023. Why is that not in quotes? Bleeding. And she went to an OB/GYN for care. They confirmed the pregnancy ended around that time. Yes, Clayton says this whole thing was a sham, but that's another issue. Okay, cool. We all know that timeline. Let's move on.
Whew, thank you for clearing that up, David.
I know. I'm so grateful that we have you here to explain this to us.
What's your point, David?
Get to it.
Right? The next thing that happened was in early December 2023. Court administration said they would dismiss the case for lack of prosecution. Like the quotes, the overuse. Sir,
It's exactly what it
that
was.
is normal. It happens in any case when the case appears to be inactive. Court administration will just drop the case, although it can be refiled later. Maybe.
Cool
If
story,
Clayton
bro.
had done nothing, the case would have been administratively dismissed. He could have called that a win and gone home, but he
So
didn't.
could you, David. So could you, David. It's 2026, and you're still writing ridiculous blogs about this. You could have went. Why didn't you go away, David? For the same reason Clayton didn't. David.
In mid-December 2023, Clayton hired a lawyer to appear in the paternity case. That lawyer, Greg Woodnick, filed a bunch of things, basically asking the court to find that Laura lied and
Laura
asking
lied.
the court to say the whole case was bullshit. He pushed back hard. Yeah, I see what you did there. Hard.
Well
Fair
played.
enough. Maybe. This is where it gets tricky.
Oh, wow. I'm ready to learn, David. I'm ready to learn.
You ready?
Take
You
us to
buckle up?
church, David.
I don't know if I want to go to that church.
I'm about to get plus 10 IQ points. Get
Wait, go
ready.
down just a second or go up? I don't know. Yeah, this is where it gets tricky.
Okay.
When Woodnick first appeared in the case, Laura did not have a lawyer.
So her problem-
Wisely, wait a minute, did she not have a lawyer? I don't even remember. She's been through so many.
I feel like
can't
she
remember
had
the timeline.
2, but it was like at the very beginning, or maybe she was, I don't know. I don't know. She's had, I don't know how many lawyers we talked about. What, 14 or 15 so far? Just with
Ridiculous.
everything? Probably
Carousel.
more than
It's a
that.
clown car. Who said it was a clown car? Yes, it's a clown car. Wisely, she quickly hired a lawyer, and on December 28th, that lawyer filed a motion telling the court Laura was no longer pregnant and the case should be dismissed as moot. Makes sense.
Moot. Sorry.
What's in your coffee? Did you put a little Bailey's in there?
No, I don't have any Baileys. I should get some, though. I should get some.
In fairness to Clayton, the motion to dismiss filed by Laura's first lawyer was technically wrong.
Wrong. Oh, my goodness.
He likes to tell everybody what they did wrong. I think he's that guy.
Oh, for sure he's that guy.
Yeah. Although the miscarriage mooted most of the case, Clayton. See, I don't know. His use of quotes over certain words is so ineffective. Like it's like where I would put them is not necessarily where you put them.
And where's all the color fonts, David?
I know.
Come on.
Clayton did ask for sanctions in his response, and that issue was not moot, despite the miscarriage. Based on this, I agree, as the court later ruled, the whole thing could not be dismissed as moot. Okay. Why? Why are we using that word like incessantly?
Moot.
This isn't a huge deal. It just means that even if Laura was no longer pregnant, Clayton still had a score to settle. I agree that's not a problem. His position was fair.
Then what are we doing here, David? Why are you being such a dick, David? A prick. I'm sorry. That's the word you like. You're being a prick.
I don't know. Prick, dick. I think they mean the same thing, but here is where the problem happened. He's going to tell you. He's going to let you know what was wrong.
Okay.
I told you he's that guy. After Laura's lawyer moved to dismiss on December 28, 2023, on January 3rd, 2024, Clayton's lawyer, Woodnick, filed a very specific type of motion for sanctions. This motion used something called Rule 26, which is basically a rule that says you can't file bullshit cases which have no basis. Oh, look at him. He rhymed.
He
I
did.
don't even think he meant to do that. It would have been
Good
in
job,
quotes.
David.
Bullshit, bullshit
I'm
cases, which
also
have
Dr.
no
Seuss.
basis. Right. Clayton said it was a bullshit case, and therefore he was entitled to Rule 26 sanctions. But Clayton's lawyer made a mistake. A big mistake.
Oh my goodness.
Big.
Tell us more, David.
Huge. Like that scene from Pretty Woman. Okay, I have
Yeah.
ADHD. Does anybody else have scenes from movies that just play in your head when people say certain words? That's me.
He wishes he was the pretty woman.
Big, huge. Anyway, Rule 26 has something called a safe harbor. I won't bore you with the details, thank God. But it works
Maritime
like
law,
this.
David?
Courts are busy and they are used to seeing everyone say the other party is lying. That happens in
Oh.
most, if not all cases. Yawn.
Hmm.
You have to feel bad for court staff. How do they know who to believe?
Right, David.
Rather than
They're
hearing
very busy.
yeah, so we're just going to keep clogging it up with bullshit motions. Oh
Mhm.
wait.
Right.
Oh wait, the
right.
irony. Rather than hearing every petty dispute over he said, she said, the courts have created this funky system where a party can ask for sanctions, meaning monetary penalties for all you idiots out there who don't know what monetary sanctions are.
Idiots. All of you.
Stop, Kat. If someone files a bullshit case, but there's a catch. You can't file the motion for sanctions unless you give a clear written warning first.
Okay. Clear.
He needs a warning shot.
Idiots.
That warning must be specific, and it must follow the letter of the rule.
Okay.
And once you give that warning, the party who allegedly filed the bullshit case has a safe way out. So are you saying you're the party that allegedly filed the bullshit case?
Kind of sounds like what you're saying, David. It sounds a lot like what you're saying.
I feel like he says a lot.
A lot.
Without
Sure
saying, or
does.
admits to a lot of things without actually saying it.
Interesting,
Okay.
David.
They have an absolute right to drop the case within a fixed time period. Currently 10 working days after the notice is given. If the bad guy takes this safe harbor, they get to drop the case and they get immunity from sanctions for doing the right thing. This saves the court staff from having to deal with all these nasty disputes. It's
Nasty, the
thing.
rumors and the nastiness.
Oh my God, why is he so condescending?
I don't know, David. I don't know.
It's a good thing. Even if is me third grade education, David. Third grade. Okay. It's a good thing, even is mean some people like words. It's a good thing, even if this means some people who file bullshit cases gets to walk away. Proofread.
Sounds a lot like your client. I probably wouldn't even hint that they're bullshit to, the internet. But I bet he's going to tell us more, Buffy.
I don't know how, like, they should. I'm sure they did. I'm sure somebody
Hi,
took that
80s.
ran with it.
Oh, I'm sure. Hi, 80s.
Hi, 80s. This is where Clayton screwed up. He's going to tell everybody where they messed up. He's so smart.
So smart. The
He
smartest.
is so smart.
He passed the bar the first try in Arizona. Did you know he also passed the bar first try in California? Did you know that, Buffy?
Llama, did you know that he was hired by fucking Johnny Depp?
Oh, Cousin's Gardner's
Fucking
grandma,
Johnny
but
Depp.
still counts.
Oh, for
Oh
God's
my
sake.
goodness, David.
Oh my God.
Okay.
Oh, Lord. Okay, so this is where Clayton screwed up. He filed a motion for sanctions, but he forgot to give the 10-day written warning. Oops. You still think his team is rock solid, Dave Neal?
Are you kidding me?
Y'all got a hard on for Dave, don't you?
Sure does.
They do. I think
Did
so.
you idiot. Wow. Oh, okay. Oh my gosh.
Hard on for Dave, don't you? That's the second time he's been mentioned in his blog posts.
Mm-hmm.
His lawyer just filed the motion without following the proper steps. A first-year law student can tell you what that mistake means. If you don't follow the rule, you cannot get sanctions. You are done.
Idiots.
Literally, 100,000 cases say this with no exceptions. In fact,
That works.
if you file a motion for sanctions without following the rule, you open yourself up for getting sanctioned for filing a bullshit motion yourself. Got all that? This is
Got it.
exactly what happened here.
I'm gonna get it
To
tattooed
fix
on my arm.
this, I tried to talk to Clayton's lawyer, but he snubbed me. He snubbed me.
He did not, David.
He did.
Oh my God. Did he hurt your one feeling, David? So sorry. Mean lawyers.
I understand why. When you make a mistake, it is hard to admit it. Oh,
Oh,
oh, so close to the point. It's like, that's fair and that's
Okay.
life, but it is bad behavior as a lawyer.
Bad. Like mood. Bad.
Oh my God.
Sorry.
No, I was just thinking we have ba and moo. I was like, it's just barnyards.
Just
We are-
barnyard law. That's what he practices. Barnyard law.
Barnyard law. We are supposed to be bigger and better than this. Look,
I mean, this
he's
is pretty
appealing
much
to
a
his-
cockfight. Sorry, go ahead. What'd you say?
No, you're right. If you fuck up, the first thing you do is admit it, fix it, and apologize. You know, like you did on your tweet. Sorry.
But
Move on.
also,
Own it.
try not to do the same behavior again. You got to learn from it. You got to learn from it, David. Learn from it. That's
Yeah.
true.
If you don't learn anything, then it was for naught.
Yeah,
Mhm.
David.
Yeah, he forgot that part.
That makes you a
He's a slow.
bad human.
He's slow. He's learning. He's learning. He'll catch up. I have faith in him. He's a
He
smart
was-
guy.
he's
He was hired by Johnny Depp.
Right?
He's
He
a
passed
smart
the
guy.
bar first try in 2 states.
First try. Twice.
Huh?
First try twice. Oh, Lord. Okay.
Oh, I think this is
So-
us being pricks, Buffy. I think this
We-
might
we-
be what
we
he
are
was
being
referring
pricks.
to.
We should not be pricks, Llama.
Right.
And he will
Just-
try not to be.
Kind of seems like he's being one first, but okay.
It's all like he does it first, and then he's like, "Y'all stop being mean." I don't know. It's like the guy who hits you and then runs,
Right.
like, and points at you. Like you hit him back, and then they point at you. Stop hitting me. Anyway,
Exactly.
after Clayton's lawyer refused to withdraw his bullshit sanctions motions, I did what the rule requires. I gave him a written notice that I was going to seek sanctions against him, and I gave him a chance to fix this. He was
And it's
entitled to
good.
the same safe harbor he forgot to give my client. See what a nice
What an
guy he
idiot.
is.
He's so nice. Humble. He is so humble, Buffy. It's amazing. Nobody's like David.
Hmm.
It's
don't
so
like him.
hard to take any of this seriously.
I don't like him.
Yeah, it didn't take long for us to reach that conclusion. Yikes, David.
Well, I was pretty pissed about the 39-page motion to withdraw or extend time. That was unnecessary, and I automatically don't like you.
Right.
Initially, he refused, but I explained to him that was incredibly dumb. Of course you did. Why would you not take every chance to tell somebody how dumb they are?
Mm-hmm.
Because it put him at risk of paying all Laura's legal fees. $35K, that's all.
That's it.
There was
Okay.
I was like, where are we at, Clayton?
Well, I
There
mean,
was
her lawyer, Corey Keith, didn't respond back because there was no discussion. She gave him nothing to do anything, I guess, to charge, fees
That's true.
for anything. So there's that.
There was no question he did not follow the rules. So there's no question his sanctions motions was fatally defective.
Idiot.
He was going to lose. No question in my mind. In addition to threatening to file my own sanctions motion, which would have been appropriate, I also drafted a separate motion that asked the judge to toss Clayton's sanction motion based on his failure to follow the rules. This is called a motion for judgment on the pleadings.
Oh,
Thank
you. Had
I
no
know,
idea.
right? Like we couldn't read the title on the top of the document.
Did he get his extension of time at all? Just wondering.
Under our local requirements, I could not just run out and file that request. I had to talk to Clayton's lawyer about this, and I had to give him a fair chance to fix this problem before I took it to the judge.
Right.
I asked
Right.
Clayton's lawyer to speak to me about this on Saturday, March 30th. No response was received. I asked again the next day on Easter Sunday.
Yeah. Like, come on.
He took a
Jeez.
day off. Can you believe it? It's not that he took Easter Sunday off to spend with his family.
Or the whole weekend, a holiday weekend. But sure,
Right.
David. Sure, David.
Again, no response. I finally sent an email today, April 3rd, 2024, telling Clayton's lawyer that if he did not respond, I was going to file my motion with the court, asking the court to rule that Clayton's sanctions motion was defective as a matter of law. Clayton's lawyer did not respond to my email, so I called the guy and he wouldn't take my call. I finally left a message saying if he wouldn't speak to me by 4 p.m. Oh my gosh. It didn't sound like a Laura response. If you don't respond to me by 4 p.m., I'm having the babies. I was going to file my motion and tell the judge he was refusing to speak with me as required by the rules. That would have looked really bad on his part. A few minutes later, I got an email saying Clayton's lawyer caved. He agreed to withdraw the motion for sanctions that he filed way back in January. This means the issue is off the table. Oops.
Oopsies.
Here is the withdrawal request Clayton's lawyer filed, and here's the draft motion.
It's not great.
It's probably the same thing we just read.
Yeah.
And
if I learn anything more about it, I'm going to be pissed.
And here's the draft motion I threatened to file if he didn't withdraw that pleading. You can reach your own conclusions.
He keeps using the word threatened as like, maybe you shouldn't word it that way. But no, he means it. He means it. Do I have to scroll? Okay. Sorry.
So, there you go. You can reach your own conclusions, but reading between the lines, I think what happens is obvious. Clayton's lawyer jumped the gun, filed a motion too soon that did not comply with the rules, and he forced both sides to spend a lot of money battling over this issue. Right? Right?
When okay. All right.
Okay. Yeah. After I was hired, I went back and checked for any mistakes made by any of the lawyers, like I always do. And I immediately noticed this big one. To do my job as an advocate, I tried to ask Clayton's lawyer to fix the problem by withdrawing his motion. And at first, he refused to do the right thing. I then pushed forward by drafting a motion asking the court to rule in our favor on this issue. At the last minute, rather than defending his mistake, Clayton's lawyer caved and admitted defeat.
What's your point, David?
Defeat! I beat him because he's an idiot. Wow. Okay.
This is not a bad thing, Llama.
He's so aggressive.
He is. He is
So
very aggressive.
Unnecessarily aggressive. Yikes, David. Yikes.
And condescending.
And condescending.
It's very condescending.
Like, who hurt you, David? Who hurt you?
Right? I actually have respect for Clayton's lawyer doing the right thing here.
Scuff.
That's what I'm saying. It's so condescending. That is exactly what he should have done. And if he had refused, I would have called him to the carpet on that mistake. And he would have lost hard. He could have faced serious financial sanctions for failing to follow the rule. Glad he changed his mind. It was the right thing to do. Does that mean Clayton's lawyer is incompetent? No, absolutely not. Over the last 20 plus years, I've seen a lot of lawyers make the same mistake. See how condescending? It typically happens when the lawyer gets too emotionally involved and they lose their objective professionalism. Oh, that is rich coming from this guy. Okay. I am not saying that is what happened here. It is absolutely what you're saying happened here. Otherwise, you wouldn't have taken the time to type it out. And honestly, I don't care. And I don't believe that either. I do care that Clayton's lawyer eventually followed what the rules required him to do. And I give him credit for that choice. It was the right move. Hard to do, but glad it happened. Does that end the case? No, absolutely not. Which is why I did not understand Clayton's initial refusal to withdraw this silly motion. There are like 3 to 4 other ways to ask for sanctions. And those other ways don't have the same strict requirements as the one rule cited in the now withdrawn sanctions motion. What this means is simple. Clayton is still asking for sanctions against Laura. And if the court rules in his favor at trial, he can still ask for some, but probably not all, of his attorney's fees to be paid by Laura. I have explained that to her, and she fully understands.
Does she? Does she? This fucking guy, man. He's something else. Wow. I wonder if the back of his hand hurts from all the backhanded compliments he gives all day.
Punching himself in the face.
Punch himself in the face, high-fiving himself. Being like, yeah, David, we did it.
All right. So for now, onward we march. Absent a last-minute settlement, which is probably the most likely outcome. We will have a trial
known Laura
in
very
June.
long, have you, David?
Right?
Have you met Laura?
3 years later. And we will have a trial in June, and the judge will decide who is lying and who is telling the truth. The only issue not up for debate that day is the bullshit motion for sanctions that Clayton filed in January, which he has now withdrawn. And that is a good thing. Cool. Celebrate that win, my dude. DSG. Oh, we have a PS. Yay.
Oh boy.
A post salutation.
It's a long one too. Of course it is. Okay.
Tell
us more, David.
He is. He's going to tell you because he finally read the documents, or at least some of them. As I get more up to speed with this case, I'm really starting to lose patience with a small but vocal handful of people. Oh,
are you getting emotional, David? Are you getting emotionally invested, David?
Yes, a little emotional.
A little bit.
Men are so emotional.
So emotional.
Yeah.
Should work on that.
A vocal handful of people who are out here milking this case for personal financial gain.
It's you guys.
I'm not one of them since I'm making $0 writing this stuff.
Writing this
You,
stuff.
the guilty and the dirty, know who you are.
Guilty and dirty. Wow.
You're like a big dirty
Idiots.
raccoon, David.
Who knew that was going to be perfect? You're all a bunch of big dirty raccoons. Be nice to David, guys. Be nice to him. Come on. He's getting up to speed. It's fine. He admits when he makes mistakes.
You're a dick, David.
These people, not naming names, are
all of you guys.
being a prick.
Being a prick. It's me. It's me. I'm the prick. Okay, tell us more about the people you David.
These people, not naming names, are generally blogging or hosting YouTube videos every day to talk about the case.
I don't know anybody like that, David.
We're the problem. It's me.
Actually, David, we only do this 3 times a week. Okay.
Correct.
Follow the rules. It's 3 times a week. All right. Get all your facts straight. I know you're just getting up to speed. All right. It's 3. Yeah. Not every day.
He's not up to speed on the case, Bam.
You idiot.
But they're not really talking about the case. Not even close. He doesn't know what the case is yet because he hasn't read anything, but he knows they're not talking about
They're
the
not
case.
talking about it, though. Because I don't like what they're saying.
Llama, did you know that we're not explaining all the facts?
Because we're idiots, Buffy. We're just jump
We don't.
jacks.
They don't explain all the facts, and they don't give both sides of the story.
So we have definitely given both sides of the story. Your client is a dumb bitch. Sir, let me catch you up real quick.
Like any real journalist would.
Oh,
And
that's a slight at Dave Neal without
it
saying
is
his name again.
Yeah, well, I mean, he's already said it twice. Why stop now?
Because 3rd time summons him like Beetlejuice. That's why.
That's how it works.
Yeah. Dave is scared he's just going to appear out of nowhere next to his desk. So he's afraid to say his
So
name
many
3
Daves.
times. Well, so far, Dave's seemed great. It's David's. We're having a little bit of a problem here.
It's true. Okay. So they don't explain all the facts and they don't give both sides of the story like any real journalist would. And at the end of the day, they don't give a shit about this case. And they don't give a shit about the people involved or the truth. They are nothing but mosquitoes sucking their meager living things. Sucking their meager living things out of the First Amendment I fought so hard to protect.
What?
You're a mosquito. Smack.
Talk about sucking.
Really?
I think you need to have a talk with your client, sir. We're here.
Mosquito.
We're here because of her sucking. Thank you very much. Let me get you up to speed again, David.
But also, mosquitoes don't stop buzzing in your ear.
So out of the First Amendment, I fought so hard to protect, but I don't like how you're using it. So
yeah, not like that. Not like that.
Not like that.
I believe in the First Amendment, but not like that.
Okay.
No.
Okay.
These are human leeches. These human leeches are selling half-truths and twisting shit way out of perspective in order to increase the drama. So much drama.
Shame on you guys. Stop writing your
thereby-
blogs.
And thereby getting a
David.
few more pennies of Google AdSense revenue and a few super chat bucks to pay for breadsticks.
Now that reference makes sense to us, Buffy.
Breadsticks.
Now we get the breadsticks reference.
Because I didn't get the breadstick reference when I listened to this song. I was like, I'm sure this is funny, but I don't know why. Now I get it.
What kind of breadstick? Breadsticks from where? Like Pizza Hut?
Oh,
breadsticks?
Olive
This
Garden
doesn't
has
look
the
good.
Olive Garden has really good breadsticks.
Yeah. I don't know if we have Olive Garden money. We might have Fazoli money, but I don't know.
I don't know.
I don't know if we have Olive Garden money, but I don't know if we have Olive Garden money. I don't know if we have Olive Garden money, but I don't know if we have Olive Garden money. I don't know if we have Olive Garden money, but I don't know if we have Olive Garden money. I don't know if we have Olive Garden money, but I don't know if we have Olive Garden money. I don't know if we have Olive Garden money, but I don't know if we have Olive Garden money. I don't know if we have Olive Garden money, but I don't know if we have Olive Garden money. I don't know if we have Olive Garden money, but I don't know if we have Olive Garden money. I don't know if we have Olive Garden money, but I don't know if we have Olive Garden money. I don't know if we have Olive Garden money, but I don't know if we have Olive Garden money. I don't know if we have Olive Garden money, but I don't know if we have Olive Garden money. I don't know if we have Olive Garden money, but I don't know if we have Olive Garden mon
I love Olive Garden.
Wow, David. Those are some strong opinions. But okay. Is this the first time he's ever been on the internet before?
Yeah.
I think so.
Apparently, it's his first day. He'll
Bring
learn.
out the puppets. Trash. You guys are not respectable journalists with your fucking breadstick money.
It honestly makes me puke.
Wow.
We could have breadsticks with the wine. I feel like it pairs nicely.
Yeah, get those carbs in, soak out that alcohol so I'm not so hungover the next day. Yeah. All right.
You know what? The Olive Garden breadsticks with the Alfredo sauce to dip it in. Get the large because you're gonna need it.
Oh.
Fuck these sick, selfish, lying assholes. Assholes. Fuck these sick, selfish, lying assholes. Should I clarify how I feel?
Oh, you got big emotions, David.
Yeah.
Who hurt your feelings, David? Point on the dinosaur where they hurt you.
Trauma?
Wow, you guys really got under his skin in one day. You sick, selfish, lying assholes, all of you. All of you. Hurt David's one feeling like that. How dare you, internet? You're so mean. Wow.
These vile scum, I mean, people are not helping anything. They are human cockroaches spreading feces on the floor and then spinning the facts to make them more dramatic than they really are, in the hopes this will drive traffic and increase revenue for their sad, pathetic lives.
Oh my God, you, David.
That sounds like Alexis had breadsticks in her mouth. So
That's what I'm thinking.
Okay.
Yikes. Show me on the doll where they hurt you, David.
Right. Hold on. Let me get the dinosaur again. Where was it, David? Where was it?
Yikes.
I think I see a
Poor
tear
guy.
coming out of your little dino.
He does need a hug, I think.
Oh, we're sorry, David.
One
Thank
day.
you, Terry, for llama and puppy breadsticks.
Oh, I love breadsticks.
Thank you. All the breadsticks for us, David.
Yeah. One day. Wait a minute. Now I'm lost. Okay, one day these trash humans will wake up and realize that lying for money is not a good way to live.
Ah, says the lawyer.
That's the lawyer.
David, you are so funny. People don't tell you how funny you are. You are funny.
Or maybe they will never see their sins. Either way, I look forward to reading their obituaries briefly before throwing them in the trash where they belong.
David!
All the best!
David!
Wow. I mean, that was a hell of a closing line,
Wow.
right?
Yeah. Oh, that's
I look
Buffy
forward
gets
to-
the breadsticks and Lava gets a gavel. If you get we're gonna have to change that command. Amos! I need you to change that command later so Buffy gets her breadsticks too. Wow, David. Let's read the comments. I bet are there any comments? I don't know. We'll see. No.
With the Alfredo sauce. You gotta
At least not from the original. I'm sure there are comments somewhere, but not on this version of it.
Oh man, that stinks. I want it.
David.
That last line. Wow. Like,
You guys really hurt.
I
his
look
feelings.
forward to reading their obituaries briefly before throwing them in the trash where they belong.
I mean, I could be a petty bitch too, David, but
Yeah, okay. I mean, I have been known to say that I'm not going to say on the internet what I've been known to say, but
Right, Minnie? Maybe he wasn't all actually writing this to his client, the liar who lies. Laura Owens. Oh my goodness, David. Donna, someone who's been around for a long time. Dave Neal's wife was pregnant and was craving Olive Garden breadsticks, and he was doing a live talking about taking her to dinner. And people were giving Dave breadstick money. There's even more depth to this lore. Okay. Money to take Tasha out to dinner. And it kind of became a running joke that he wasn't making enough money off Laura Owens to buy much more than breadsticks. So now you know that's the history of breadsticks in this case.
I appreciate the lore because breadsticks are free.
Bravo. Right.
I do
Bravo.
love Olive Garden breadsticks, and I too craved Olive Garden when I was pregnant with Owen.
There we go. Look, now the Nightbot. I get a gavel. Terry gets pink glitter. You get breadsticks, Buffy. So do the right thing.
I love
in
it.
this video. Oh, wow. There's the origin of when we became the Ponka.
What is a punka?
Oh, Pond Scum Posse.
Oh, pond scum. Okay. I'm sure we'll get to it. I'm sure it lives in the blogs.
Sure. Guys, these were just his first 2 blogs, and already the internet has made him cry.
He's making everybody cry on the internet. I've cried.
Right? You're like, I don't understand why the internet's being mean to me. I was so nice about it. Even though you were like,
I'll be nice
condescending
to
as
you
fuck.
if you be nice to me.
Right?
No, that's not what he said. He said, be nice to me and I'll think about being nice to you.
That's exactly what he said. You're being a prick, David. Being a prick.
This guy's
Wow.
got problems.
This is a lawyer.
He's unnecessarily angry. For a guy who just got here.
Right. You just got here, sir. Okay. And you're just like with a megaphone. People thought we were ridiculously hard to listen to. Pass the torch to this guy. Oh my goodness. Wow. Yes. Applause for Don for today's lore. Oh my gosh. Can I get glitter wine? Oh, maybe. But then
wait, they have glitter wine? There's wine with glitter in it?
we can put edible glitter in it. Sure.
But does it like fall to the bottom or does it swirl and just kind of sit there? I need to know this.
They'll probably
I would
probably
probably drink glitter wine. I don't like glitter that I have to clean up, but I would drink glitter wine. Does that get stuck in your teeth?
Probably. Oh my gosh. That'd be so funny. Minnie says douche canoe was the nicest of terms referring to him. Yeah, when he's called y'all sick, selfish, lying assholes.
Cockroaches. Human cockroaches spreading feces on the floor.
Trash humans. Gross, you guys.
Jesus.
Be better.
He is
Yikes. We're Celine Dion in comparison, right? Oh, we are. Oh my goodness. Well, that's something. Let me see.
I've
real
never been
quick.
compared to Celine Dion before.
No. Let's see. What else do we have? Oh, the next ones are no, we got like 2 hours. We can probably do a few more if you wanted to. You guys want to do some more? Because we got notice of non-objection, which is 3 pages. It's probably the shortest thing Gingras probably writes in this whole fucking thing. And then more blogs. I think we can do it. Let's do it. Are you in, Buff? You're muted.
I like to talk to myself.
Are you busy writing a blog telling me that's how much of a selfish asshole I am?
You don't want to hear what I was saying about you when you couldn't hear it.
That I'm amazing, that I'm the smartest person that ever lived, and that the internet is full of stupids who are
Cockroaches.
Cockroaches. Ugh. More, please, because we're all masochists. Okay, check my Discord. Okay, well, I can't do all of the things. What do you want? Oh. Oh, well, thank you for catching that now. Nobody bothered to tell me there was a typo today.
Where?
It said go gund me. Instead of go fund
Go
me.
gun me. Oh, wah, wah. I didn't see
It's
it.
okay. Of course nobody told me because they're all lying, selfish assholes on the internet. David said so it's fine. I'm just kidding. You guys are not like that. I would never call you that. I would never. I wonder if glitter wine counts as fiber. Could do a science experiment and find out. All right. Well, let's go ahead and move
it's not
along.
that I don't appreciate glitter. I just don't like cleaning up glitter.
Delete all these other ones we already did. All right. So next, I don't know. So apparently David files a notice of non-objection in response to their withdrawal of a motion. Do you have to file this? This doesn't seem necessary. Maybe it is. I don't know. But it seems kind of like, well, if they don't object, then it's fine. I don't know. But let's see what David has to say. Probably
He wrote this in 3 pages.
Yeah. So
I
he's
don't believe
capable
it.
of doing it. It's basically, dear Judge Mata, I'm a fucking genius. So I'm fine with it. Thanks. Bye. David.
All the best.
All the best, David. All right. So, probably should have got some more coffee, but whatever. Okay. On April 3rd, respondent Clayton Echard filed a lengthy 16-page motion seeking to withdraw an early Rule 26 sanctions motion he filed in his case on January 3rd, 2024.
He seriously said that?
Yes.
He has the nerve to say something about his filing being lengthy when there was 39 pages just to ask for an extension of time.
Wow, David.
This guy is like a hypocrite on like a massive level.
Oh, by the way, I forgot to tell you that this is April 4th, the next day after the blogs and everything. This is the very next day. We'll be on just the 4th for a little while.
Pull your hair back away from your microphone. Oh. It's rubbing. There you go. I don't know, just rubbed it.
I had cockroach hands. I don't know how they work. What are they
called? Lobster hands.
Or lobster hands.
Lobster claws? You can't.
Just a bug, a trash bug on the internet. First, technically, the motion to withdraw could be denied because it does not comply with Rule 9C. Oh, a new rule, guys. The motion does not contain a Rule 9 certificate, which is not surprising because Clayton's counsel did not meet and confer with Laura's counsel before the motion was filed. Are you fucking kidding me, David? You little tattletale. And first of all, this is why the internet didn't like you, David. It's this kind of behavior. Play nice with the other kids, David. That issue notwithstanding, in the interest of efficiency, because that's David's favorite other word, apparently, Miss Owens does not oppose Mr. Echard's motion to withdraw the prior sanctions motion, and she agrees the court may consider that motion essentially moot. Second, the motion to withdraw, which could have been a simple one-page, one-line stipulation, isn't really what it appears to be. Sir!
Sir, I think I said that about yours.
No way. Oh my gosh. 39 pages we've read when we knew, and we're just dumb cockroaches, knew you could have just made it a fucking sentence and it would have been granted. Oh my gosh. Okay. Barbecue Queen, the amount of times I thought to myself, no fucking way. While you read his dumbass read. Me too, girl. Me too. The motion isn't really about withdrawing anything. If it was, Clayton's counsel would have met and conferred, learned that Laura would stipulate to the relief requested, and no motion was necessary. Clayton's motion is really not a motion at all. It is a rhetorical manifesto. Sir.
Did he really? The man who's writing angry blogs.
Oh my gosh. Okay. It is a rhetorical manifesto, which serves 2, maybe 3 main functions. For one, it hurls pejoratives at both Laura and undersigned counsel. You hurt his feelings, Woodnick. You hurt his feelings.
Pejoratives? You called people cockroaches?
Fucking
Assholes? What?
Special ed. Like, really, David? Really? Okay.
Oh, God.
Well, you know what? It's fine because David says, okay, that's fine. That's fine, guys. It's fine with David. He's fine. He's just going to move on. He's so good at it. He even said so in his blog. We assume this was done as a response to the longer motion Laura filed on Monday, which the court denied on Tuesday. Okay, fair. Sir, okay. The pseudo motion also seems to preemptively argue certain legal points regarding the availability and propriety of sanctions and fees. Why do this in a motion that asks to withdraw a request for sanctions? Idiots. Duh.
Why say all the bullshit you said in a motion to extend?
The answer is obvious, Buffy.
Is it?
Mr. Echard wants to plant seeds in the court's mind, hoping to harvest them later. It's a conspiracy, Buffy.
He's an evil mastermind.
Ridiculous, David. As
So ridiculous.
anyone who knows the undersigned will attest, he is sometimes talking to himself in the third person. As anyone who knows the undersigned will attest, he is sometimes, often, long-winded, and usually is happy to engage in lively and wordy debates over matters of law. But now is not the time or place for that.
Sir!
Yeah, Buffy. It's not the time or place. We're in a
He
place
started
of
it
forum.
with that 39-page document.
Buffy, this court is busy and has other matters to attend to. Come on. He said it. It's true.
39 pages.
Oh, my
You asked for
gosh.
more time.
Yes, we did. I Am the Princess. We just finished reading the Pond Scum.
No, he didn't say pond scum yet.
What did he say? I thought
He
he
said
did.
vile
Trap-
scum.
What?
He
Pool.
said vile scum, but he
Oh.
didn't say pond scum.
Right.
That might be
Forgot.
a specific phrase, but he said
Different
vile scum.
fractions.
Which made me think of Star Wars. Like,
Yeah. Rebel Scum. Mm-hmm.
yeah.
David.
I'm so glad you were there.
Barbecue Queen. Echard planted seeds in her head twice. Gold star for you today, barbecue queen. Gold star. Show it off to everybody. Be like, I made a BJ joke on a YouTube chat and I got a gold star today.
I'm going to tell my
five.
dad. He'll be so proud.
Oh. Since we're in bragger paradise over here, we can just brag about anything. It's fine. We're very humble. As such, with the undersigned can and surely will provide the court with a helpful and thorough explanation of the correct legal standards for sanctions, fees, and other related issues, which will basically destroy the remarks in Mr. Echard's pseudo motion. This will have to wait for the proper time and place. For now, we should all focus on more pressing concerns.
Okay.
He is so unserious. David. What?
The lack of self-awareness is peak.
I'm going to write it all out for you, Judge. Not now. We're in a place of decorum and have standards here, and I'm following those. No, pay no attention to the first one they wrote about just need more time. Wow, David. Okay. I don't see a certificate here. I don't know if you need one, but you might as well just include it, David. Cross all the T's and I's. And
it would be an extra page, and he didn't want to give him any more ammunition. Because,
oh my
God. I hope Woodnick was like, yeah, okay, let's talk about the 39-page motion to extend. Like, because I'm not getting over that. I am holding a grudge.
You're right. It took us 4 hours, David. And you're saying, oh, the court's time is important. Okay. Okay. All right. So that takes us then to, because, he files that and he's going to write 2 more blogs the next day.
Of course.
So 4 blogs in 24 hours. You're handling this very well, David. Very well. So good for you. Let's see how he handles his emotions today. What names is he going to call people on the internet? Any guesses? My guesses? We'll see. All right. Do you want to go for it, or
sure?
You're doing a great job.
A bang up job.
For being an idiot, you're doing great.
I'm doing good. I'm kind of dumb, but I got this.
Don't stir up more drama, Buffy. Just all the drama. Don't stir it up. Don't
so much drama. For being a cockroach, I'm not doing too bad. It's impossible to cover everything in a single post, but you'll try. So I want to take a minute to break something down about what is happening in Owen versus Echard bachelor case. As explained yesterday, Clayton Echard withdrew his motion for sanctions against Laura. What does that mean? It just means Clayton has dropped the motion. He filed back in January asking the court to punish Laura for lying about being pregnant. Does this mean the case is over? No.
You told us this yesterday, David.
Yeah. He is going to make sure you understand, because clearly you guys are too stupid to get the message.
Stupid idiots.
Does that mean Laura didn't lie? No. Wait, didn't lie? That doesn't mean she didn't. Wait, is it double negative? Does that mean the court isn't going to punish someone for lying? No. All of those issues remain on the table for the judge to resolve. The only change in the case is that Laura claimed there was a technical problem with the original sanctions motion Clayton filed. Clayton's lawyer disputed this, but rather than fighting about it, not every dispute is worth fighting over, even when you're right. Really.
Wow,
Clayton
David. Wow. Really? It's not worth fighting over, but I'm going to write 2 more blogs today.
Clayton agreed to withdraw his original motion.
Move this up.
He remains free to still ask for sanctions in other ways. Now, what's next? We have a very short trial, 2 hours, set for June 10th. The issues for trial are very narrow. So let's try to get a grip on what is and what is not going to happen. First,
Thank goodness we have his guidance.
Laura, I know. I'm so glad he's here.
Mhm.
I'm too stupid to understand this. Now, what's next? Okay, we already did that. First, Laura started this case by filing a petition for court order fraternity. We know this. We already know this. We
I
know
didn't
how it
know that.
started.
That is
That's why everybody's
brand
talking.
new information, David. It's almost like we just got here. Is he caught up on the case now?
He probably read a file or two and
Well,
felt like, oh, I understand now how we got here. In legal terms, this is called an establishment petition. What that means is Laura was asking the court to make a finding that A, she was pregnant, and B, Clayton was the father. Put differently, she wanted the court to establish Clayton was the father of her unborn child / children.
we're confused too, David, about how many there were magic uterus babies.
Well, I mean, they I'm gonna there's one, there's two, there's one. As everyone knows, Clayton denies Laura was pregnant, and he denies he was the father. He says he never actually had sex with Laura. You need to wait and hear what he says about this on the stand under oath, because it may not be exactly what you are expecting. For her part,
What's
Laura
that
was-
mean?
that he's going to say he had, or I don't know what. I guess that he expected him to say like that he did.
You just wait, guys. I know I'm not caught up on the case yet. I'm telling you.
But wait till how he answers this question on the stand. It may not be what you think.
Because I'm going
Pretty sure
to question
his,
him.
his
in a
story
way-
hasn't changed though.
No, not at all. Maybe you should go read the other stuff your client wrote, sir. But okay.
For her part, Laura will say she did have she did have sex with Clayton. And after that happened, she tested positive for pregnancy at least 5 times. And for the record, Clayton has argued that an HPT, and in case you don't know what that means, we're going to put it in parentheses for you.
Oof,
Home
thank you.
pregnancy test is somehow not proof that a woman is pregnant.
David, what? As a woman? Thank you for educating me. You idiot. You're the idiot here, David.
What he probably means is that an HPT is not conclusive. See his mincing of words.
Oh, shut the fuck up, David. Freaking
It's an
dirty rat dude.
indicator. What he probably means is that an HPT is not conclusive proof that a woman is pregnant. And to save him any surprise, Laura agrees 100%.
Okay. Does she, though? Does she? I don't think she does. David.
According to her attorney, she agrees.
Okay, David.
It is absolutely possible to have a false positive on a test. But how common is that?
Tell us, because I bet it's very rare, because everything rare in the world happens to your client. So much. It's astonishing, but I bet she's a rare one in this one too, isn't she, David? What are the odds, David? What are the odds?
He's going to tell you.
Good.
Consider
Good.
this. According to
Consider-
pregnancy kit manufacturers, most at-home pregnancy tests are 98% to 99% accurate when you use them exactly as instructed. Positive results can be trusted, but you can get a false negative result if you take the test too soon. Blood tests tend to be more expensive and inconvenient.
In fact, you still get one. You're an idiot, David.
I mean, you still get a blood test.
Exactly.
Like it's usually the very next step.
The very next one where they,
Yeah.
do that to also confirm and check your levels as proof
Right.
of pregnancy, David.
Hmm.
So, sure.
So, yes, if Clayton argues HTPs are not 100% accurate, he will get no pushback from Laura. because that's true. The tests are only about 98 or 99% accurate. So if Laura took one, there is a 1 or 2% chance she wasn't pregnant.
But they said only false negatives. So wouldn't one of them had to have been negative to prove his point? Am I missing something here, or no? Okay.
I don't think he knows what he's talking about.
Yeah. Go on, tell us more, David,
You know,
who
it's like
doesn't
when
have a uterus.
somebody they use so many words, they turn the whole to cover up the fact that they don't know what they're talking about, and you're completely confused. Yeah, that was this conversation.
Right.
So if Laura took one test, there's a 1 or 2% chance she wasn't pregnant. Bear in mind, Laura took multiple HPT tests, and they all showed the same thing. Okay, so that makes your percentage go up.
Right.
I guess. I don't know. I mean, I took a bunch of P tests every time I found out I was pregnant because I didn't believe it. I was like, nah, I'm gonna go buy 2 more. Nah, let me go take 2 more.
But even afterwards, when you do find out you are, wasn't a part of you also like, maybe I'm wrong. Maybe I'm just gonna go in there and just late, like my body's just being weird. Yeah, I did anyway.
Well, it took 10 years in between pregnancy tests. I was like, don't walk too fast. We don't want to break it.
That's true. That's true. She aced. Hey, she aced.
Shake it off.
All those pregnancy tests on the first try, guys. First try, 5 times. Bunch of rock stars over here on this side. Get in line, idiots on the internet.
What an idiot. Okay, so in case you didn't know, Llama.
Okay.
For the record, there's no requirement that a woman obtain a 100% reliable pregnancy test before she files maternity action.
Okay. Fair.
Okay.
Fine.
In case you were wondering, in case you asked, because I know you asked. I think you asked. I don't think anybody asked. In fact, there's no requirement that the woman have any pregnancy tests at all.
Which is honestly wild.
Well,
but
I know that is kind of weird that anybody can just walk in, ask for a paternity without having to prove even pregnancy.
Yeah, because you know what? Like if you want any government benefits like WIC or SNAP, guess what you got to do? You got to go get a doctor's note clarifying that you're pregnant before you can apply for them.
I remember I got
almost
WIC
like there's a reason for doing that.
Second baby, and I had to get an ultrasound and I think a letter signed off by my doctor.
Same. Yeah, it's almost like there's a reason for that. Maybe it should be that way for court too. I don't know.
Only for the government, not to sue an individual. Apparently,
that's true. I forgot.
Yeah, government cares if they're paying, but if it's just a random person, nah. Okay, they'll figure it out. Okay, and that's my soapbox for that. Anyway, so the only requirement under Arizona law is that the woman must have some plausible basis to think she is pregnant. I feel like that whole law needs to be written. If that is what it says, there should be some lobbying to get that changed.
It's kind of crazy.
That's crazy. It is crazy. Because that's crazy. That could be something as simple as she had sex, missed a period, and is experiencing symptoms of pregnancy. I really have a hard time believing I could say, I missed a period, paternity.
Exactly. Yeah, like what?
Because there are so many reasons to miss your period. Stress, sickness. There's so many reasons that you can skip a period. And just to think that you could automatically jump to a paternity suit for having a missed period, it's crazy.
Also, your client never needed to file anything in the first place because she had all the rights to everything. So,
or just wait till the babies are born. Shit.
Exactly.
Anyway. So, missed a period, experiencing symptoms of pregnancy, weight gain, morning sickness. So basically, while a positive test is nice, it is absolutely, positively not a prerequisite to filing a paternity action. In addition, it is important to note Laura's belief she was pregnant was not based solely on HTPs. I think you mean HPTs. I think you're confused. Home test
Idiots.
pregnancies, home pregnancy tests. She also had a blood test done, which is arguably more reliable. That test was also positive. In this extremely odd situation, here's what I expect will happen at trial.
Oh.
Technically, Laura is still the petitioner, kind of like the plaintiff, for those of you who didn't know how this works.
You idiots.
That means we will get to go first at trial, but every issue raised in Laura's petition is moot because she claims she had a miscarriage in November 2023. Thus, she is no longer pregnant. There is no baby or babies on the way, and thus there is no issue of paternity for the court to establish. That is all moot now, and courts generally will not resolve moot issues.
Right. Okay. Okay.
I plan to explain all this to the judge.
Oh, I can't wait to read that. Can't wait.
And I will ask her to simply dismiss Laura's paternity petition as moot. That doesn't mean she loses. It just means there's no remaining issue of paternity for the court to decide. For this part, Clayton is not satisfied with the outcome. He wants more. He is
Why, David?
Something called an order or judgment of non-paternity. Why? Why?
You know what?
Why?
I think I'm pregnant with Dave Gingras' baby. I guess I can just go file one, right? It's fine. It's fine. It's fine, right? It's fine.
Allegedly pregnant with Gingras' baby. Please don't bring that on. You're going to get a defamation suit.
It's fine. He believes in the First Amendment.
It's fine. It's fine. We'll just raise money. We'll just raise money for your lawsuit.
It's fine.
It's fine.
I'm going to put on a hell of a fucking fundraiser. I'll tell you what. No. All right. Continue on.
Yeah. This is why you would want an order of non-paternity. I mean, I understood your point. The point you were making was like, you don't want just people to say that you're, you want
exactly
or non-paternity. Basically, in case you didn't know what that meant.
Oh,
I love the mansplaining. Like,
mm-hmm.
He really does think everybody's stupid, right? In case you didn't know what an order of non-paternity is. Basically, yes. He wants the court to say he is not the father, despite that issue being mute. Oh my God, I'm so tired of hearing that word.
Use a new word, David. Get a thesaurus, David.
Right? And he wants the court to go even further by making a finding that Laura was never actually pregnant to begin with. This is one of the most misunderstood aspects of this case. So I want to make something very clear. In litigation, when a party takes a position or makes a claim, the person making the claim generally bears the burden of proof on that issue. Mm-hmm. Yeah. Mm-hmm. Yeah. Mm-hmm.
Right. Proof that you should be able to claim because everybody that's pregnant or has has that proof. So
yeah, David, how's that going for your client?
I mean, if it's all on Clayton to find it, sure. Question is, where is it, David?
How's that going? Where that burden of proof?
Still waiting for all the evidence to come out. It's inconclusive. Evidence still pending.
Oh, wait. In case you didn't understand what that meant, what that means is if you claim something is true, you have to prove it is true with admissible evidence. And if you fail to meet your burden of proof, the court will find against you on whatever issue you are trying to prove.
Hi, elbow feet. Welcome. Welcome.
In this case, Laura is no longer claiming to be pregnant. So that issue is, say it with me,
moot.
She has mountains of proof that she was pregnant. Mountains.
Oh shit! A whole ass mountains.
There's mountains.
Oh
Mountains.
wow,
There's
plural
a lot.
too.
I'm telling you, this is a slam dunk case.
Have they given that to the prosecutor's office of the state of Arizona, where your client is,
Mountains.
facing 14 felonies? I'd be giving all that evidence to them. I would think, all of it, David. But okay, mountains.
There are mountains.
Okay.
She has mountains of proof that she was pregnant, despite claims to the contrary. However, she agrees it is impossible for the court to establish that Clayton was the father, because DNA tests conducted in the case were inconclusive. You already said that, right? And there was no longer any fetus to test. This is why Laura has asked to dismiss the case back in December 2023.
It's interesting how he put the statistics of testing for home pregnancy tests, but not for this. It's very interesting that you seem to be leaving that out here, David. But let's see. Let's give him a chance. He's probably going to educate us later because he is a super genius. And
He's
we're just
very
cockroaches.
smart, man.
Very smart.
You're all
The
just
smartest.
stupid.
Mm-hmm. Mm-hmm.
Allow me to explain to you why this matters, Llama.
Oh, thank goodness. He's so good at explaining things.
Arizona law provides a set of rules. Rules! I swear, that's like his war cry, like his battle cries. Rules. You know how some people are like,
fucking nerd.
He's like, rules.
As a fellow nerd, I'm going to call you a fucking nerd. All right. And not in a good way.
No.
Nobody likes people like that, David. This is why.
Rules.
For sure.
Educate
us.
Oh my God.
Educate us.
Arizona law provides a set of rules for how paternity can be established. This is normally done by DNA testing, and it is important to understand exactly what the law says about this. So take a look for yourself. Here is the full statute. A man is presumed to be the father of the child if 1. He and the mother of the child were married at any time in the 10 months immediately preceding the birth, or the child was born within 10 months after the marriage is terminated by death, annulment, declaration of invalidity, or dissolution of marriage, or after the court enters a decree of legal separation.
Doesn't mean they're the biological father.
No, but they will go on the birth certificate in some states because, yeah.
Well, some you
we
can't
had to
even
make
get
sure.
divorced until after you have the baby, too.
I know. I was still like waiting for paperwork to be solidified for mine. I mean, it was crazy. Anyway, genetic testing affirms at least a 95% probability of paternity. A birth certificate is signed by the mother and father of a child born out of wedlock. 4. A notarized or witnessed statement is signed by both parents acknowledging paternity, or separate, substantially similar notarized or witnessed statements are signed by both parents acknowledging paternity. Okay. What is the point? What is your point, David?
What's your point, David?
What is it, David?
See point number 2. There.
Oh.
That's the point.
The genetic testing, guys. If
In
only.
most paternity cases, and yes, this is not his first rodeo, the issue of paternity requires DNA testing to be performed, and the test results must come back showing a 95% probability match to the alleged father. If that happens, the court will issue an order finding paternity has been legally established. In our case, the DNA tests were inconclusive.
All
That
3
means,
times. What are the odds of that, David?
right? I mean, there was no fetal DNA.
Think about it, David.
Nothing to test. That means they did not have enough tissue. Think about that. Let's unpack that for a minute. To give a meaningful result, which is different from saying the test affirmatively excluded Clayton as the father. No. I need you to go back and say that a little slower to yourself. There was not enough tissue. Why wouldn't there be enough tissue in twin pregnancies 5 months in?
Let's tell him about it, Buffy.
I mean, apparently he likes to mansplain it to me. Let me mansplain it to him. I'm a woman-splain it to you.
My hair. Sorry.
Sorry. Got this.
It's fine.
Cheer
Like a
you up.
pilot. Thanks.
You need your aviators. Okay. So where are we at? Okay. The test results must come back showing 95% probability match alleged father. If that happens, the court will issue an order finding paternity has been legally established. And our we read all this stuff. I'm trying to figure out where I left off.
We're very serious people.
Because Laura was the petitioner in this paternity case, and because she cannot show a DNA test with a 95% probability that Clayton was the father, the court is going to conclude that paternity was not shown here. Okay. Okay. That just leaves Clayton's counterclaim, in which he asks for an affirmative finding that he was not the father. But remember, the party who makes a claim bears the burden of proving that claim. And since Arizona's paternity statutes generally require a very high degree of proof, it is unclear how Clayton plans to meet that burden at trial.
A very high degree of proof.
It's so funny how he walks into his own trap, right? Like,
Right, David. Okay.
Yes, Clayton's testimony about all of this is still evidence, but by asking the court for a specific factual finding in his favor, what Clayton is doing is similar to a contested paternity case in which the alleged father walks into court and tells the judge, the mom claims, I am the father of her child, but I deny this, and I want you to rule in my favor based solely on my word, which is kind of what she's doing. Because on the issue of Clayton's paternity, his word and Laura's rebuttal is the only evidence the court is going to hear. No family law judge anywhere in the country would make a decision of non-paternity based solely on the father's denial, but that is what Clayton is seeking.
I don't think that I see things differently, sir. Sorry, David.
I feel like that's exactly what Laura was expecting.
Yeah.
It's funny how that went full circle, right?
Can't wait to see these mountains of evidence. Can't wait till he proves us.
I can't wait to watch the trial.
Wrongs. I know, right?
We're only in April.
Oh my God, it's gonna take forever. I know.
You know.
Thanks, David.
The point here. What's your point, David?
Oh.
The point here is that given the unusual posture of this case, Laura's position is that if Clayton wants the court to find that Laura was never pregnant and or that Clayton was never the biological father, those are issues Clayton must prove. He bears the burden on both of those matters, and the standard of evidence the court will likely apply is very high. It's called clear and convincing proof. As I keep saying, everyone needs to wait for all the evidence to be presented in court. I know, and I'm here for it.
I agree, David.
Once that happens, Laura is confident there was no possible way that Clayton will be able to meet the high evidentiary burden for the claims he is making. If she is correct, this case will end with a judgment in favor of neither side. To me, that seems like an incredible waste of time and resources, but at least for now, that is where things are headed. DSG.
Wow. David. Okay. You make my brain hurt, David.
Mhm.
You make my brain
Yeah.
hurt real bad.
I
Dan
want a hot dog
Montana.
real bad.
You know, I met her in real life. I had her
Oh,
record
that's
that
cool.
into my phone, and it was my ringer for like years.
That's so cool.
Mm-hmm. Yeah, she was at a gay bar. I was there. It was a good time. She's very sweet and lovely. Little to no, Dan Montana says, little to no fetal DNA means she has never, ever, 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 never been pregnant. It stays in the mother for at least 20 years, David. Why didn't you include that, David? Interesting. All right.
I
Oh, but
kinda
don't
wanna
worry, you
see how
guys. Go
I
ahead.
wanna see what kind of fetal DNA is still in my body. I'm gonna go get a test just to see.
I mean, we just learned that was even a thing. But,
I know, but now I'm
well,
just
guess what,
curious.
guys? In case he wasn't clear, he's gonna clear more things up.
Oh,
All right.
good. I wasn't sure I understood
So,
before. I'm so
come back.
glad there is a follow-up to this because
So many questions for David.
oh, guys, he didn't want to spend so much time on this today.
So I didn't want to spend so much time on this today, but another issue just came up that I think is important enough to share because the internet made fun of me and I don't want them to reply back to me. So I'm just going to write a blog about it. A common theme, in fact, maybe the only theme in this case, is the idea that there were no medical records to show Laura Owens was ever pregnant. Clayton's lawyer recently made that representation to me, and at the time he did, I was not familiar enough with the case to understand what the facts show. He's still catching up, but he didn't have all the facts, guys. Now that I'm getting familiar, there is something really important that needs to be said. First, the idea that there are no medical records to show Laura Owens was ever pregnant is 100% categorically false, you idiots. It's false. You dumb dummies. Yes, there are records. Tons of records, guys. Tons. Are they 100% perfect? Shut up, David.
Oh my God. Did he really just say that?
Are they 100% perfect? Are they 100% conclusive?
Are they 100% authentic?
Right. That is a mixed question of personal opinion. Shut up, David. Personal opinion.
I don't think personal opinion wins cases. I'm pretty sure facts do.
Yeah. What would it take to make you believe you were pregnant, Buffy? Think about it. What would it take for you? What? I'm waiting.
Oh, you want a real answer? Like, I would
idiots.
wait until I go see a doctor and get a sonogram and he calls me and tells me that my numbers look good and that, my progesterone's a little low. So he's going to, prescribe something to help a little bit because he feels it's a little low and that he wants to see me again in a few weeks or at least in a week to make sure my numbers are going up. But that's what would it take me.
That's just your dumb personal opinion. All right.
My dumb personal experience.
That is a mixed question of personal opinion. What would it take to make you believe you were pregnant? And it's ultimately something the judge in our case will have to consider. Okay. Laura's position is clear. If you want to say you don't trust her, that's your opinion, idiot. If you want to say you don't find her medical records to be convincing, that's your opinion. But it is absolutely dead wrong for anyone to say that no records exist, because they do. With Laura's express permission, I want to share one of these records with you, even though the judge told them not to do it. Even if she gave permission, doesn't really matter. The judge said no, but okay. Oh, and
It's a
before you go there,
recommendation. It's
Mm.
it's more of a recommend. It's a suggestion, really.
right, that thing that your client kind of bitched at the judge for wanting to do, but now, okay, all right, you're right. Oh, I'm sorry. Oh, and before you go there, this is to us, Buffy. No, there is no court order stopping Laura from publishing her own records. Okay.
Okay, what do you first? I have a question.
Mhm.
What do you call a medical record?
Something that comes from a medical place.
Yeah,
Yeah.
that's what I would call it. Where's all she has is pictures of an HPT.
Mountains of evidence of medical files, though, Buffy. We're just idiots. We just look
Mountains
up the
of
word.
pictures of a home pregnancy test. Got it.
Right. We don't know what we're talking about. No. Now, as you probably know, Laura took lots and lots of home pregnancy tests.
Hmm.
You said 5, but okay. Lots and lots. A whole mountain of home pregnancy tests. She even took a test that Clayton bought and gave to her. All those tests were positive. And yes, Clayton believes all of those tests were wrong. Although I don't know what medical expertise he has to express such an opinion. That is something the trial will explore. Well, that's actually not medical evidence at all. It's just a P test that you read
I was about to
as
say
a
it's not a
non.
medical record.
No,
That's what I'm talking about. What do you
Mm-mm.
call a medical record? A pregnancy
that.
test that you buy at Walgreens is not a medical record.
Right? Nah, that means literally nothing. Literally nothing. She did take a P test at Banner, a walk-in clinic. Yeah, which again means nothing, David. But let's put that aside and assume every home pregnancy test is unreliable. That's not what people are saying. It's not the tests that were faulty, David. It's that your client was injecting herself or doing something for them to test positive. No one's blaming the test. What other evidence does Laura have? Well, before I answer that, let's look at what Clayton's lawyer told the court about this exact point. On January 25th, 2024, Clayton's lawyer filed a brief reply to petitioner's response to motion for sanctions. In that brief, Clayton's lawyer said this to the court. Petitioner wanting to be pregnant and being pregnant are two different things. Despite her repeated assertions, positive HCG tests are not verifiable medical evidence of pregnancy. Parenthetically, per the Office on Women's Health, a blood test, which Laura ostensibly never underwent, is the best way for a doctor to confirm pregnancy. Got that, idiots? Couple of key points here. First, Clayton's lawyer told the court positive HCG tests, which is what home pregnancy tests are not verifiable medical evidence of pregnancy. Again, it's not exactly clear why Clayton claims that every home pregnancy test sold in America is somehow meaningless. But for the purpose of this discussion, let's ignore that point. Let's ignore that point, guys. Let's ignore it because if you think about it for too long, yikes. Amos, every medical facility I know still has to do a confirmation test by their own staff. I know, right, Amy? It's crazy.
It's almost like there are medical records that prove a pregnancy.
Text back at the look on Llama's face. Reading face cracks me up. I do have one of those faces. Second, Clayton's lawyer also told the court that the best way for a doctor to confirm pregnancy is with a blood test. Okay, fine. And of course, Clayton's lawyer asked for sanctions against Laura because he claims she never underwent any blood test. Can you guess where this is going? Yep.
Oh.
On October 16th, 2023, Laura had a blood test done at a lab. Oh, at October 16th? Interesting. Want to guess what the results showed? Pregnant. But don't take my word for it. The report can be viewed right here. Let's fucking open it up and see what's going on here. Because your client said from her other lawyer that she had a miscarriage before then. So
Why did I just
let's see.
look up like it was going to open on my tab? You clicked it and I was like, but it didn't open up on my
Where
duh.
is it?
I
Oh,
messed up.
wow, David. Her HCG quantitative is 102, David. David, sit down. Sit down. Let us explain to you.
I don't really know what the number is. So explain to me.
I think it goes into like the thousands, even tens of thousands. This means you're not
Well,
pregnant. I
yes.
can absolutely
But
tell
when was
you.
this taken?
This was taken allegedly October 16th, 2023.
Oh, she was pregnant in June, right? No, May.
End of May, June. Yeah, May.
Oh,
May 20th.
she only has 102 quantitative at
Mhm.
it 5 months later.
Even if she miscarried
She
and
would not. No, well,
Yeah.
no.
it can take like 4 weeks sometimes, but still, again,
Now with
you're
2 big
not
old
pregnant
babies and your
technically.
stomach looking like that on a Zoom call.
Yeah, that's right. That's true. But even then, it actually does the opposite, David. It says she's not pregnant. So while you're using this as proof that she's pregnant, it's actually proof she's not pregnant. But, it's fine.
It would have taken a while for those to go down to 102, but she wouldn't have a belly that big.
Actually, I think it goes down quite quickly, but at a certain point.
I don't know. If she was 4 months like that pregnant, it would not have gone down that drastically in October. She was that pregnant in November. Like her stomach was very
Yeah.
large. That's what I'm saying. Her numbers would have been like a lot higher because it wouldn't have been that low with her stomach that large.
Right?
I know what
Look
I'm
at this.
saying. It doesn't matter if you don't know what I'm saying.
Well, you know what? David is saying, listen here, dumb fucks. This is her medical evidence that she is pregnant, was pregnant, whatever. Oh, David. It's not what that means.
You are so dumb.
So let's go back to here to remind ourselves exact. Laura had a blood test done at a lab. Want to guess what the results showed? Pregnant. No, it didn't, sir. Because even if you want to say, oh, well, she miscarried, so still that means you're not pregnant, babe. Sorry. So no, I'm not going to take your word for it because you're wrong. Wrong, David. Wrong. I bet he doesn't do apology for this. Maybe he will. I don't know. We'll see. Does this conclusively prove Laura is telling the truth and Clayton is lying? Of course not, because it doesn't, she's not pregnant at all. That is something the judge will decide for us.
I'm so glad. I don't need the judge to tell me that.
But make no mistake, if anyone tells you there are no medical records supporting Laura's pregnancy, that person is lying to you. Well, the one you just showed us, David, does not prove that. So,
well,
that would then make
that was okay. I'm sorry, but you would have a lot more than just that little 100 quantitative HCG 5 months into a pregnancy.
For somebody who loves rules, you would think he'd pay attention to the rules of like medicine. There's certain things that have to be done by a certain time and all that jazz. But
I wish I was that confident to be wrong and that confident.
Well, I'm not I'm sorry, you're right. We're not medical experts, so we can't possibly understand how to interpret that, even though neither is he.
You could have put that in Chat GPT and it would have told him the right answer.
Exactly. And if anyone tells you the only proof Laura had was take-home P-type home pregnancy test, that person is lying to you. I'm sorry, but this is all wrong. You're wrong, David. You're absolutely wrong. Update. Oh, update. A Newegg Twitter account, clearly a troll, just made a comment that actually seemed to raise a valid point. What, David? What? Okay. The guy, interesting, you assume that it's a guy, David, but okay. The guy looked at Laura's test posted above and noted something. The HCG level was 102. No fucking shit, David. That is high enough to count as positive for pregnancy. But my troll friend said it was fishy. Oh my God. Why is this important? Per Professor Google. So you can use Google if you're not a medical expert. It's fine. But if we do it, we're fucking idiots. Got it. The detection of HCG is used to confirm your pregnancy. After you conceive, when the sperm fertilizes the egg, you develop placenta begins to produce and release HCG. But David, it can also indicate that you're no longer pregnant if it's that low, that far along. But don't Google too hard. You might break your brain. Now, I am no expert. But apparently, HCG levels change a lot during pregnancy. Oh, do they, David? Oh, do they? Oh, do they? They start very low and get higher during that pregnancy. A lot higher per this chart. Let's look at it, David. Let's look at it. Hold on, it's loading. All right, let's look at all the different levels. Oh, 4 weeks, 0 to 750. Then it goes up. By the way, if you're on the very low side of these, that means you are probably having some complications. All right. Like that can be pretty nerve-wracking for a woman, if I do remember correctly. But you see how high those go, David? October 16th, or whenever the fuck it was your stupid ass client took this blood test. And it was only 120. I don't think so, David.
Was it 120? Was it like 102?
102.
I think it was like 102. It was like not
know.
even that high.
My
It
brain
said
hurts
102.
because it's so dumb. It was 102. Yes, sorry, I just looked it back up. 102. 102, David. And you're going to argue that she's still fucking pregnant? No, not unless she happened to get knocked up again in the month of October, in the 4 weeks leading up to that, when she also was busy miscarrying twins. Because I don't know about you, but I know all of the other women like me who have miscarried really want to fuck after you've just lost a baby, David. You're an idiot, David. Just an idiot. So, per this chart, at the start of pregnancy, HCG levels can range from 0 to 750. And as things progress, the levels go all the way up to a huge number like 210,000, even higher for twins. Doesn't help your case, David. All else being equal, that suggests a test showing HCG levels of 102 several months into Laura's pregnancy raised a big red flag. Sure does. My troll friend, now blocked, sorry, bro, seemed to think this absolutely sinks Laura's case. I mean, if Laura's level in the 5 month were only 102 and they should have been 210,000 or more if it's twins, yeah, that kind of looks bad for Laura, right? I don't agree for 2 reasons. Okay.
I bet he is going to blame the miscarriage.
And then it's like, well, where are those? Where's that information at, David? I'm sure you'll learn from Google what happens next. Good God. First, the
Can
same
you switch it back to the blog?
Yeah, because I'm not
Sorry.
doing that. Thank you.
I just wanted to be able to see where you were.
No. Thank you. I'm bad at it. First, the same page linked above says this. Falling HCG levels may show a pregnancy loss, miscarriage. Sure. But you know what that also means? It means technically she is not pregnant, David. No. Okay, since Laura claimed she had a miscarriage at some point after this test was done. What? That is not what she's claiming, sir. What? What, David?
When you said the test was done in October?
Yeah.
Shit.
October. Hold on. Let's put it back up here. October 16th, you guys. And her hormone is 102, and then she miscarries. That's also not how that
Okay,
works.
so where's the blood test from the first one? Let's compare from when she was pregnant, the blood test she got when she was first, pregnant, and the second one. This one,
It's almost
because
like she would have had one before this, because it's pretty, how it goes.
Yeah, we need to be able to compare those numbers.
Daya, this might be the dumbest thing you've said so far. So he doesn't even know when the fuck his client allegedly miscarried at this point. So
Apparently she
great
doesn't
job.
either.
No,
I think he
it's
said
crazy,
November.
right? But Corey says it was September, October. Okay.
But if those numbers were that low in October, then it was October. And also we're babies.
Also, how many weeks is that? I think that's still 20 weeks at 10-13. If anything, the levels may be completely consistent with Laura's story. She got pregnant, something went wrong, and she had a miscarriage. I don't have the scientific knowledge to know what a woman's HCG levels should be shortly after a non-viable pregnancy ends, but it sure seems like they would drop, maybe all the way down to 0.
It sure sounds like you should know what you're talking about before you start talking.
Open your fucking mouth, David. But here's the thing. I don't want to learn that because it looks real bad for my client. Yeah, it does. Yeah, it does, fucking David. But here's the second thing. And it is the key point that everyone, like all you fucking idiots, seem to be missing. I don't care about the HCG numbers in her 5th month. He doesn't care, guys. David does not care. That issue is not relevant here because he said so, guys. He doesn't care. You bunch of idiots. Why not? How could that possibly not matter? Well, here's why. The HCG number in the 5th month does not matter because it does not matter if Laura was or was not ever pregnant. Read that again. I will read that again, sir. Let me do it. Here's why. The HCG number in the 5th month does not matter because it does not matter if Laura was or was not ever pregnant. But didn't you bring this up as proof of her having medical records of being pregnant? So you're like, here's the proof, but you know what? Doesn't matter. Boom. Magic. Because I said so. Okay. Okay, David.
David.
Think about this and please try to understand. Laura is no longer pregnant. Good job for figuring it out. I know you just got here, David, but you got there real quick. Good job, buddy. Good job. Bravo. I wish I had a genius male brain like yours. She admits this. According to her, the miscarriage happened at some point way back in November 2023. Oh, did it, David? Oh, did it? Oh, your client's not a fucking liar who lies. We're supposed to believe her? Ask your client where the death certificates are, David. Go ahead. Ask her how she miscarried in November and her numbers were at 102 in the middle of fucking October. It's not how it works, David. It's not how it works. What an idiot. God, this guy. Fucking mansplaining everything to us. Fucking.
I'm about to go get me some popcorn and just watch you rant.
This guy. According to her, I already said that. Now, in April 2024, she does not want the court to declare Clayton as the father because there is no baby for him to be the father of. Or maybe there never was, David. Because of this strange situation where Laura is no longer pregnant and is not asking the court to say Clayton was or was not the dad, it literally makes no legal difference whether Laura was ever actually pregnant in the first place. What a fuckface. Fuckface, David.
No offense, David.
You're a fuckface. You're a fuckface, David. You can use that word in your next blog. Of course, Clayton says she lied about the whole thing from the start, and that twist is what changes the situation drastically. Clayton's claim is being made to support his request for sanctions and to support his request for a finding of non-paternity. So now we need to ask, how can he get sanctions? What does he need to prove? You need to suck a fucking dick, David. That's what you need to do. Go ask Laura for tips. Apparently, she has a lot of free time. This guy is just infuriating. You don't even know when your client, you're not even tracking her lies. So, okay, David, a whole bag of dicks. Lainey agrees with me. To get sanctions, I'm sure if he ever hears this, he'll be like, they're using such awful profanity against me, and I'm supposed to take them seriously? Probably.
Okay, let's defer to the last blog we just read.
Right? He's definitely giving a hot dog and one swallow vibes.
Oh.
To get sanctions, Clayton will have to prove something different. That Laura had no basis to even think she was pregnant with the case when first filed. That is totally and completely different than saying Laura was or wasn't pregnant months later. Is it? You fucking, ugh. We are focused on what she believed on August 1st when she should have been at a fucking doctor by then. David. How many weeks pregnant was she been, David? Enough to go to the fucking doctor, I can tell you that. But I forgot you don't have any medical experience and, somebody needs that or you just can't be bothered to check Google. It's weird. It's weird. We are focused on what she believed on August 1st, 2023, not whether that belief was still correct months later down the road. Okay. People are allowed to bring cases which end up failing because what they initially believed later turns out to be incorrect. Okay. The only thing that matters for purpose of sanctions is whether the person knew their claim was groundless at the time it was brought. And that is a very high hurdle to clear. Well, sit the fuck down, David. Obviously, if a person believes they are pregnant on January 1st and they file a paternity action that day, but they had a miscarriage a month later, the court can't sanction the woman for bringing a groundless case because the case was not groundless at the time it was filed. Same thing here. To repeat, the standard that matters and the standard the court will be asked to decide is not whether Laura was ever actually pregnant. I could stipulate she was never pregnant and we can still win. Then do it. Then do it. Do it, David. I double dog dare you. Only a good lawyer would have done that and would have won the whole fucking case, David. You would have been the only lawyer that could have done that. But you're not as smart as I thought you were. Now, here for purposes of what Clayton is seeking, the correct legal standard is, did Laura have any reasonable basis to think she might be pregnant when the case was first filed on August 1st, 2023? That's it. That is the entire case. HCG levels months later, not even the slightest bit relevant, you fucking idiots. And if you don't believe that, take more time and think about it. You will eventually see the light. Oh, wow, David. Thank you for showing us the light. If Laura was never pregnant, but she had a good faith reason to think she was, but she fucking didn't, David, Clayton will lose his request for sanctions. For the umpteenth time, this is what will happen, even if Laura was never actually pregnant. We know that's not what happens, but okay. Let's see these comments. Jane Dodo Bird says, if Laura was pregnant with twins, how'd she know this without a sonogram? David? Where's the sonogram, David? Also, there are meds that can cause someone to test HCG positive, and based on her history with mental health and epilepsy, I'd be surprised if she wasn't on a drug that caused this. What are the odds, David? Janice says, did you know there's a video of Laura with a lawyer representing her at the October 24th hearing? Here's a link to the video if you've not seen it yet, where she says, I'm 24 weeks pregnant. And if she had that HCG test, how many, 10 days before that?
Because it says it was reported on the 17th, which means she got it back on the 17th, which was a week before.
And trust me, that doctor would have told her exactly what was happening. It wouldn't be like a month later, like, oh, I think I might have miscarried. No, the doctor would have fucking told you what's going on with you. It would have, again, been an emergency situation. Your dumbass and your client's fucking dumbass don't know how any of it works. David needs to go live in a cult. Oh my gosh. Yeah, it was all in good faith, you guys. Come on. You guys are all idiots. All idiots. The whole internet. He's the only person that's right on all of the internet. Fuck the medical experts that say differently. But only David knows what's best with the law. Well, that wraps up. Oh, wait, I forgot. I still have. That wraps up today. We ended up getting through 2 days. So good thing I did these money things in advance. I'll have to go through some stuff, but that's okay. Let's see how much those 2 days cost Clayton. Are you guys ready for it? I guess. All right, let's get back to where we were here. Let me see. We need this one. There we go. Look at what you've done to me, David. You've gotten me all worked up, David. Hope you're happy with yourself. All right. I don't know why that one's not right and showing $60,000, but you know what? I'm tired all the time. It's fine. Actually, this day was supposed to say 60,987 and 56,987. My bad. Well, you want to know how much the third cost him with that bullshit fucking motion they had to file and dumb shit? $3,052 fucking dollars in one day, guys.
Oh,
one
okay.
day.
I see how what that comment you made was. Now I know why that day cost so much. Fuck. All that case law.
Yeah. 3 emails from David reviewed and staffed as one was overtly threatening call to bar council ethics hotline. They called the fucking bar ethics hotline, guys. First draft response David will hold. Ethics advice, they didn't charge him for that, which is nice. Edits to draft motion to withdrawal. Edits to draft motion to withdrawal and legal research. Almost $1,500 fucking dollars for his bullshit.
One was overtly threatening.
Yeah.
I want to see that MO.
$3,000. That's a lot in legal fees. And remember, you know who else needs legal fees? Mike Maricini, because Laura's still playing the same fucking bullshit games with him. All right. So if you can, please donate to Mike Maricini's fundraiser if she's trying to appeal or may file a new DVRO against Michael. What is that?
I have no idea. I didn't do it.
Somebody else is in the Canva, and I think her name is Amos. But there's the QR code for his fundraiser. You can find it in the description of this video or pinned to our chat because she doesn't ever let up. And so remember, those fees add up fast. People are like, why does he need so much money? And appellate lawyers are probably more expensive. So, I mean, all lawyers are expensive. I don't know that to be true, but they are a specialty. So there's a smaller group of them. Let's see. Then, so the in total just for that day is $64,000 in one day.
Oh my God.
All right. So we'll go ahead and move on to the next one because I already did what we were going to cover on Thursday. Oh, but by the way, tomorrow morning at 11 a.m. Eastern, for our Bestie members in hire, me and Terry will be you can have coffee with us for an hour. We just chit chat and hang out. It's a lot of fun. If you're besties in hire, that's at 11 a.m. Look at the cute llama on that cup. I love that. You're going to see my work in progress of things. We'll get to that tomorrow or Thursday. So we left off $64,000. Now, for what we just read, which was the fourth, all right, that I'm not going to object, and David's stupid fucking blog post, almost another $1,000 in one day. Because there were emails from David, emailed him back with a request to meet and confer, call with Neumeister regarding expert work and waiting for records. So they're starting to, prep for trial as well. More emails from David, which
Email
we
from
will get
Jingris
into next.
again.
Yeah, we get to read a lot of those emails here very,
What?
very soon.
I'm just looking at how he listed it on the again.
Again.
Well, at least
And
it's not
so
Laura.
just those 2 days, we went from $60,000 to $65,000 in 2 days. And at this point, there are about two and a half-ish months from trial. So we're going to see these racking up very quickly. And a lot of it's not necessary. But, David, he doesn't want there to be all these legal fees, you guys. It's not necessary, he says. Okay, David. Okay. Well, also, oh wait, hold on, let me go back. If you missed the morning announcement, we have partnered up with Winks and her team and other people in the JFC community. We want to host a Mike Maricini mega stream fundraiser come this June. We're finalizing a final date, but it will be in June. If you are a content creator, an advocate, or some way want to be a part of the fundraiser, please email me at Llama. Well, no, I'm sorry, that's not right. Tara, surprisingly, TARA at tcwtmedia.com, or Winks at, I didn't copy it down later because I was going to do this for the next one later tonight. Why? Well, with her email, which is Winks and some numbers. Oh, there we go. 5813 winks at 5183 at gmail.com. And we'll get in touch with you with details. It's going to be hopefully a 12-hour mega stream if we have enough people and activities to sign on. I volunteered to sit here all day. We already have some people that are confirming, which is very exciting. Can't wait to see who all it is. We have a list, but I don't want to forget anybody. So even if you've never covered Laura Owens, but you've just learned about it and you want to and help raise money for one of her victims that she is currently still not letting go of and trying to ruin his life, then please help us out with this fundraiser. We've seen other big communities do fundraisers like these. LawTube, Karen Reed, Kelsey Simmons, they raise money and do this kind of stuff all the time. And I think the JFC community can do this too. And I think we can do it big, So let's all do that. Email us if you want to be a part of it. with that, I guess if you haven't noted, our new time change is going to be to 10 a.m. Eastern now. Since Llama does wake up early, though I can't guarantee I'll be lively every morning, but maybe. Um, let's see. Anything else for tonight? Today? It's only 2. I don't think so, though.
Nope.
All right. Well, thank you all for being with us today. Thank you for those that already said that they had donated to Mike's GoFundMe earlier. And again, if you don't have the money to donate, that's fine. All right. That's more than okay. Nobody wants you to donate it if you don't have it. But what you can do, what is free, is to share the link for his GoFundMe on all of your social media. That is just as important right now to help fundraise. So that's free. Do that if you have social media. But until next time, we'll see you all Thursday. If our brains haven't exploded yet from David's nonsense. My brain hurts. It really does.
It's always
Really?
like that after reading something from Jingers, though. Well, it was like that Friday for me, and
It is.
they're already today. So I anticipate this is just an expectation.
That's true. Probably. We have so much more to go. We'll be back. I forgot to tell you what we're going to be learning next because I had to.
We don't know. We
skip a whole
did
day.
yesterday. Yeah, I would say we did a whole day today.
Well, we get a blog and we get a motion to compel lunch.
Oh.
And Laura files a bar complaint against Greg Woodnick. So that's what we have to look forward to.
Oh, goody.
Yeah.
That sounds like a interesting.
So basically, he's going to ask the
Oh my
judge, will
God.
you make Woodnick have lunch with me? He
And he
won't
had
for some reason, and I don't know why.
the gall to talk about all the drama.
Oh, he is a drama llama.
Is the drama.
Okay.
Yeah.
Oh my gosh, what a
Am
drama
I the
llama.
drama?
Hmm.
Need to find that soundbite.
Yes.
Is it me? Am
Is it
I
me?
the
Am I-
drama?
Yeah, it's you. All right, friends. Until Thursday, you all have a great rest of the day. And until next time, go forth and be amazing. All right. Bye, friends.